We would like to inform you that the Commission will be commencing shortly. Ceci est une annonce que la Commission commencera sous peu. Order, please. À l'ordre, s'il vous plaît. This sitting of the Foreign Interference Commission is now in session. Commissioner Hogue is presiding. Cette séance de la Commission sur l'ingérence étrangère est maintenant en cours. La commissaire Hogue préside. The time is 10 a.m.
Good morning, everybody. Bonjour.
Bonjour. Bonjour.
Good morning. Welcome.
So, Mr. Cameron, I understand you're the council leading the examination this morning. I have a cell with me, but I have no intent of using it except to keep the time.
Which reminds me. It's warm. Yeah. There's no translation. Good morning, Madam Commissioner. My name's Gordon Cameron. I am one of the Commission Counsel, and this morning I'm joined by Maître Jean-Philippe Mackay, who will be one of the counsel also leading the witnesses in these questions. We have this morning a panel of witnesses in contrast to yesterday, where we had former national security intelligence officials appearing as a panel. We have today current, or you might say incumbent, national security intelligence officials, and the parties will have noted a difference in today's proceeding relative to what we've had so far this week, is that these the people before you are appearing as witnesses giving evidence, as opposed to just having a panel discussion. So let me introduce the panel to you, Madam Commissioner. Sitting closest to you is Mr. Daniel Rogers, who's the Deputy National Security and Intelligence Advisor at the Privy Council Office.
Good morning.
In the middle of the panel and sitting beside Mr. Rogers is Mr. David Vignon, the Director of the Canadian Security Intelligence Service. And sitting beside him is Ms. Alia Tayeb, the Deputy Chief of Signals Intelligence at
Bonjour.
Communications Security Establishment. If I could ask the court operator to please affirm the witnesses.
Please state your full name for the record.
Daniel Rogers,
Please spell your last name.
Rogers.
Do you solemnly affirm that the testimony you're about to give today is the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. Please state your full name for the record.
David Vigneault,
And spell your last name.
Vigneault.
Vigneault is how I spell my name, says Mr. Vigneault. Yes, I swear. New speaker.
No, split. You see it?
It's Alia Tayeb,
Okay, and spell your last name.
Tayyeb.
Do you solemnly affirm to the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much.
Thank you.
Thank you, panel. Now, just some formalities for the record. You probably have with you, but in all events, the reference I'm going to make is to the document that is entitled Institutional Report on the Protection of Information in the National or Public Interest. And for the record, parties will be able to find this by reference to its number CAN Doc 3. And I'll ask you, Mr. Rogers, as the panel's representative from the Privy Council Office, can you confirm that this report was prepared by and represents the evidence of the Government of Canada for the Commission?
Yes.
Thank you. And panel, you'll also have with you or will be familiar with a document entitled Witness Interview Summary for an interview on January 16th, 2024. And again, for the reference of parties, that has the document number WIT or WIT 4. And witnesses, do you have any corrections to make to this summary?
I do not.
Thank you. And thus, can you agree that it is an accurate summary of your interview with Commission Counsel on January 16th, 2024?
Yes.
Thank you. And finally, parties will by now be familiar with the letter from the Attorney General of Canada dated December 15th, 2024, and that is a tab or an appendix to the document that was first entered as CAN Doc 3, the institutional report. That letter had attached to it 13 redacted documents, but they were not included with the institutional report. So I would like to enter them now, and rather than run through all 13 document numbers, participants will be familiar with the set of documents I'm referring to. It begins with CAN 900 and ends with CAN 5847, and I'd ask the court operator to have those entered as the next 13 exhibits. And parties, when you're referring to these documents, functionally their exhibit number is their CAN doc number. So you would refer to it as CAN 3781 or whatever, and the court operator will probably be able to get it up on the screen for you for reference as you're conducting your examinations if you do want to have reference to any of these documents. Madam Commissioner, through you, I will make this observation for the benefit of the participants, which is that about those 13 documents, this panel can and is here to answer questions about the nature of the redactions on these documents. But this week's hearing is not the place for examination of these witnesses on the substance of the content of the documents. And on that point, again, just an observation to assist the parties in framing their questions. This panel is before you, Madam Commissioner, to speak about national security confidentiality, though they are well qualified to speak to other matters that are relevant to the Commission's mandate. They are not here today for that purpose. And questions about the substantive parts of the Commission's mandate should be saved for the hearings on those topics. Representatives of these departments, or perhaps even these witnesses, will appear again, and parties will have an opportunity at that time to ask substantive questions about the Commission's mandate, but today they are here to speak to national security confidentiality.
I do understand.
With that said, I will hand the mic over to Maître Mackay to commence the conduct of the examination.
Bonjour, Madame la Commissaire. Bonjour.
Good morning. Good morning to the witnesses. My name is Jean-Louis Macan, and I will begin the questioning of the three witnesses this morning. Before starting, what I'd like to say is that since the beginning of the week, we've had an opportunity to hear various experts or witnesses yesterday, testimonies yesterday from ex-directors, ex-members of the national security community. Today, we will be starting with evidence, so there will be repetition of certain notions that we heard this week. But nonetheless, we will be asking the witnesses to explain with a certain level of detail certain subjects that we've already spoken about this week. So to begin with, I would like to provide this information to the witnesses. When you're using acronyms, we understand that you work in an environment where acronyms are king, but we would like to ask you to not take for granted that I know or that the Commissioner is aware of what the acronyms are, nor that the members of the public know what these acronyms stand for. Monsieur Vigneault, I will begin with you. Can you describe what your role and responsibilities are within your organization? Yes, of course. As a director, the CSIS Act is very clear on the functions. As a summary, what I can say is that I'm responsible for the administration and the activities of CSIS. I'm also responsible to the Minister of Public Safety and also with respect to the management of all facets associated to national security. Question, when you're talking about the activities of the service, can you speak a little more about that? Answer, the mandate of CSIS is to gather information, produce intelligence, and provide advice to the Canadian government. So this is very well defined in the Act. From a practical level, what that means is that we have intelligence officers, professionals who work in this realm, who will try to find information that's required to provide information to the government and to meet the government's needs in this area. So our areas of work include spying, counterterrorism, foreign interference, and sabotage. All of the issues related to national security generally are included in the mandate of my organization. How do we undertake these operations? And how are we able to respond to the government's needs in this field? We can use different techniques. to go gather information. One of the factors, and this is very important as well, not only for CSIS specifically, but also for intelligence gathering generally, is the sharing of information with foreign organizations. The threat that Canada faces is not only directed towards our country, and it's not unique to Canada either. Certain aspects are, and I know that we will be talking about this later on in the Commission, but the sharing of information with foreign agencies is one of the fundamental pillars that allows our service not only to carry out our mandate, but also allow the government to continue to protect Canadians. Thank you. Question. Madam Tayeb, I have the same question for you with respect to what your role and responsibilities are within the communication security establishment. I will be answering my question in English.
As you introduced me, is Deputy Chief of Signals Intelligence at CSE. So essentially, my role within the organization is that I'm responsible for our operations under that aspect of the CSE mandate. I thought I might, because of some of the discussions about the mandate of CSE versus CSIS in some of the earlier proceedings, maybe go into a bit more depth in terms of the CSE mandate, just to put us in a good place.
And before you do so, I should have warned all of you at the beginning that we have simultaneous interpretation, various interpretations. So if you can bear in mind that we have to keep the rhythm at a certain level so that the interpreters can do their job.
Indeed. Thank you. I thought it might be instructive to just highlight the various aspects of the CSE mandate that I think will be instructive. So the first aspect, as I described, is our foreign signals intelligence mandate. And the second big pillar, I would say, is that we're the technical authority for cyber security and information assurance. And so I'll just break that down a little bit more simply by going through the 5 aspects of our mandate. So the first one being, like I said, foreign signals intelligence. And
excuse me, Ms. Tayeb. I know, just keep in mind that the interpreters have their job to do their rhythm as to.
I apologize very much. I will slow down. And so as it relates to foreign signals intelligence, which we also call SIGINT, to be more clear about that in the context of this inquiry, it involves the collection of foreign communications and other type of electronic information that would be foreign in nature, and we would also refer to that as technical collection. The second large pillar that I made reference to relates to our cybersecurity mandate. The CSE houses the Canadian Centre for Cyber Security, and so in that function is responsible for cyber defense of Canadian government institutions and also Canadian critical infrastructure, and by extension also providing advice to Canadians on how to best protect themselves from cyber threats. The third aspect of our mandate involves the conduct of foreign cyber operations, which is the newest part of our mandate that involves taking action to disrupt foreign threats. The fourth aspect involves defensive cyber operations, which involves disrupting attacks that might be levied against Canadian infrastructure, Canadian government infrastructure. And the fifth involves providing technical and operational assistance to other departments of government. And so I think in recognition of the fact that CSE has a large expertise in the technical domain, we are often asked to provide that assistance to other agencies. The Act provides for us to provide that assistance to CSIS, to RCMP, to CBSA, and to the Canadian Armed Forces. But in the conduct thereof is exclusively under the authorities of those departments at that time. This is not, the CSE is merely acting as an extension of those agencies' authorities.
And now to you, Mr. Rogers.
Thank you. Yes, I can explain a little bit my role and the role of the Privy Council Office. I've been in the national security community here in the federal government for about 20 years. Previously the Associate Chief of the Communications Security Establishment, an organization in which I spent most of my career in the intelligence world. I'm now the, as you said, Deputy National Security and Intelligence Advisor to the Prime Minister. The Privy Council Office is part of the Federal Public Service. It is a non-political department that is the Prime Minister's department. It's headed by the Clerk of the Privy Council, who's also the head of the Public Service and the Secretary to the Cabinet. Our role is primarily to assist in coordinating issues of policy and government operations to support the functioning of government. And in that context, the National Security and Intelligence Advisor, who is the most senior national security official within the Privy Council Office, helps to convene and coordinate across the federal national security community here. That includes CSE and CSIS, as well as other departments. Our role is to convene, to assist, and to advise the Prime Minister and Cabinet. We do not direct the activities of other agencies or departments who have their own accountabilities and ministerial responsibilities. But we do seek to assist in the good functioning of the community by bringing deputies, departments, agencies, and others together to form consensus and a coherent view on government policy and significant operational issues. A couple of other things I might note in the context of this process for the National Security Advisor's role and the role of PCO. PCO has a separate secretariat which supports the Minister of Democratic Institutions, and that is housed within the Privy Council Office. Also, within the branch of the National Security and Intelligence Advisor at PCO, we have a secretariat called the Intelligence Assessment Secretariat. That secretariat does not collect intelligence. It's not similar to CSIS or CSE in that respect, but it does gather and consume the intelligence from other departments and agencies across both Canada's national security community and from international partners, and produces assessments which inform government around the broader trends and issues that we see from an intelligence perspective.
Donc, peut-être une question de précision.
Question, perhaps I would like to ask. And therefore, I made a mistake because I used an acronym. Security establishment.
Une communauté du renseignement.
So we heard you, we heard you speak about the intelligence community. Can you explain what we're talking about here when we're talking about this community? Answer from Mr. Vigneault. Yes, this is an important part of our work because all of the Canadian government agencies that are working in the national security realm, we must follow the applicable acts, but also another important point are the cabinet directives with respect to intelligence. This information is provided to all of the agencies. So CSIS and CSE and other agencies who have a role to play in intelligence, we all have the same priorities. From there, every agency working within our own realms and within the applicable acts, we carry out our operations. The goal is to be able to provide information to the Government of Canada. What that means is that CSIS's work is being carried out on a daily basis with our partners, with the RCMP, with the CBSA, with Communications Security Establishment, with Global Affairs Canada, and the Privy Council Office and other departments and agencies. Every day, our activities will connect with work being done elsewhere within the government. When we collect information, we do that ourselves, but oftentimes we need support. We need to ensure that the information that we're collecting is relevant to other government agencies. So again, we work closely with those other departments and agencies. Concretely, this the practices of the community. I want to say that there are a lot of task forces at work, informal and formal task forces, a number of people who are working together, and this includes up into the deputy minister level. Sometimes we meet on a weekly or a daily or a monthly basis to allow information to be exchanged, coordination of our activities as well. Once again, departments will not get interfere in how we conduct our business, but we want to make sure that there's relevance and that there's coordination between the agencies.
An important element is the nature of the threats that Canada faces has changed greatly. In the past, CSIS could do counter espionage efforts, but now that's no longer the case. We have to inform our federal colleagues, and so there's a community of intelligence community that exists, but we also work with people outside of the federal government, and I can speak to that later. It's also important to ensure that this community, so that they'll be able to take action. The different partners will take action based on their mandate. They need to have the right information at the right time with the right analysis as to the context within which this information exists, and that's absolutely essential so that other agencies are able to act, whether it be for the border services, whether it's for immigration, whether it's for the Department of Innovation and Science with respect to foreign investment. So the community needs to be very well coordinated to be able to do our work as efficiently as possible, but also to be able to ensure that the impact of the intelligence of the information will be shared, will be used as efficiently and as possible. Mr. Vigneault, question, Mr. Vigneault, you say the agencies all have the same priorities, but then each of them have to go ahead with their tasks based on their specific mandates. Yes, that's answer. Yes, that's right. The Prime Minister chairs the cabinet meeting, and so in that meeting, the result will be a cabinet decision that will be transmitted to each of the ministers. And in my case, for the Minister of Public Security, will receive these priorities, and they will put out a departmental directive. Given our mandate, we deal with foreign interference, so how that works for CSIS, it will be different than how it will work for the national defense, for the Canadian Armed Forces, given their particular mandates. So there is where each agency has specificities, but all of that comes from the directive that comes from the cabinet. Question. You talked about collecting information, and I used two information. Between information and intelligence, there may be a little bit distinction, but you're talking about collecting intelligence information. Can you tell us how this is done, with what legal authority does the CSIS have? Well, CSIS may do technical collection of intelligence. We are given that capacity through the Act, and so that we can engage in technical operations to get information, so this can be interception of communications. And we also have the authority to collect information through the use of human sources. So this is a very important element in our work. Our professionals, our intelligence officers will determine with our individuals, and this based on their functions and based on their knowledge, based on where they work, whether or not they have access to information that could be relevant to our intelligence needs. So our professionals will enter into relationships with those individuals to establish through that relationship there will be a formalization of a relationship, and that's what we call a human source. This is a process that has to be done, so the individual may first have a contact, so there'll be somebody who'll be able to give us information. This may be a human source, would be a person who will be receiving the directives from the service and will be able to implement those directives and to bring us information. Question. So when you talk about human sources, there has to be a formal relationship. Yes, exactly, Madam Commissioner. So this needs to be a contact for any person in the public who would approach us. We have websites and we have telephone lines, and so I do invite people to contact us if they have any relevant information. But and so this would be a contact, but to formalize the human source, we have several policies and directives that do apply, and there is also the CSIS Act that has a precise outline of the formalization of the relationship there, and so of the human source. So the contact will be giving us information, and a human source can be directed to do certain things, to enter into contact with certain persons. And so these are activities that would allow us to be able to do technical collection of information. And then that is how we worked. And maybe one last thing to come back to the point that I mentioned earlier. An important element is collaboration of the agencies. A lot of the work that we do starts with information that we receive either through our government partners, CSE, for example, and also their foreign agencies. So we have CSIS have formal relationships based on the Act with over 300 agencies around the world. And so this is almost all countries. It's not all countries, but almost all countries. And there are several agencies for each country often. So this is one of the essential ways in which we do our work. Question. And Mr. Vigneault, in the context of your activities, do you have legal constraints with respect to disclosure of information or intelligence? And if so, could you please present this to us? Answer. Yes. As I indicated, the CSIS mandate, as it's been dictated by the Canadian Parliament, is to give information to the Canadian government, to the federal government, and also to take measures to reduce threats. That is a threat mitigation mandate. And so we have Article 19 of the CSIS Act, Section 19, sorry. It gives us, indicates which information should be shared. So there are limitations for classified information. And the way that we go about it, if it's a question of sharing classified information, there's a way of sharing classified information that will allow us to gain more information. So there are different possibilities, but they are somewhat limited. So I could tell you more about Section 19, and there's also Section 18, where there's a prohibition of the disclosure of the identity of the people who are undercover agents at CSIS, and as well as the disclosure of identity or information that would allow the identification of human sources. So that Section 18 is very clear in that effect. And so the employees of CSIS are subject to the law on Canadian intelligence security. Individuals, including myself, we are obliged to respect the questions of disclosure, and this is permanently bound to secrecy. And so this is the act with respect to protecting intelligence. And as the Government of Canada, we have to follow the Privy Council Office with respect to protection of information. And they have a very precise indication of how and with whom we can share information. Question. We'll come back to that in a question. Last question in link with this subject, Monsieur Vigneault. You spoke about the situation, national, internal situation in Canada, but what about partners, foreign partners or international partners? Are there constraints with respect to disclosure that follow through from foreign partners and their constraints? Answer. This is a very important question. There are constraints and there are principles that cover the sharing of information when we, as an organization, share with our partners. And there are also principles with respect to how we process information that we receive from our partners. It's important to mention how we share information with our partners. They expect us to protect the information, and so there won't be disclosure of information without asking permission. So if we share information with a specific agency, that agency is not allowed to disclose that information with other partners without asking for our permission. And another important element that flows from how the intelligence agencies in Canada work, will we ensure that we analyze the type of information that we share to ensure that that information cannot lead to any human rights violations where people may be tortured or there will be such effects. So there are very precise rules as to how we share information, and this sharing of information, I think it's important for Canadians to know that there are examinations, review agencies that review all of the information and of the service, and they have a review of that information that we share to ensure that we do it in the correct fashion and that we respect all of the directives so that there's no violation of the human rights. And the way that we receive information, the foreign agencies share information with us specifically and with other agencies of the Canadian government with a clear intention that this information cannot be shared by us with other individuals or disclosed in any public way through different processes without their authorization ahead of time. So this is what we call a third-party rule, and these are the limits that follow from our agreements. And Canadians, the way that with which we work and how we can protect our Canadians through our activities, this follows through from our partnerships. So the actions, any action that would diminish their confidence, that would have a direct impact and a negative impact for security of Canadians. Question.
Could you? And it's the same question that I asked to Mr. Vigneault earlier. Could you describe briefly the functions of your organization with reference to its legal authority to collect information?
Indeed. So our Act is really clear in this regard in terms of the authority to collect. And David made the point a minute ago when you talk about the Cabinet Directive on Foreign Intelligence Priorities. So our Act specifies that as it relates to the collective foreign signals intelligence, which I alluded to earlier, that can only be collected in accordance with Government of Canada foreign intelligence priorities. So that specification is in the Act, and that directs the specific kind of intelligence that we're able to collect under that mandate. There's definitely prohibitions on that. We may not direct our activities toward any Canadian or anyone in Canada. So that is a very distinct limitation as it relates to our foreign intelligence mandate. And so I think that's an important distinction as it relates to CSE. In conjunction with our cybersecurity mandate, which I described earlier, we're also authorized to collect information that is specific to that mandate, which is the protection of Canadian government systems and systems of importance in Canada, but again, not to direct activities at Canadians or individuals in Canada.
And we heard Mr. Vigneault describing the general legal constraints that apply to the disclosure of information, so the Security of Information Act, for example, and the specific constraints in the CSIS Act. Concerning CSE, are there specific legal constraints that apply to your activities?
Absolutely. So I should be a little bit more precise that the collection of information as it relates to our foreign intelligence mandate, I think important to note, as David did, it's expressly for to share with other government departments. So I should make that clear. We would be considered an agency that collects information for the purposes of providing that information to other government departments who require it. So we have a host of Canadian government clients who are appropriately cleared, who can receive intelligence from CSE. In terms of the Act and constraints, we do have a notable a specific mention in Section 55 of the CSE Act, which indicates that we may not disclose or information may not be disclosed that would reveal or cause to reveal anyone who would assist CSE with our mandate. So it's a bit the compendium to Section 18 of the CSIS Act, but slightly different insofar as to prescribe that to people who have been assured of their confidentiality in their efforts to assist CSE with our mandate. But as David described, that all of the other laws and government policies apply to CSE. So the policy on government security, which prescribes the handling of classified information, certainly applies to CSE employees. The Security of Information Act that David mentioned as well applies to CSE employees, the vast majority of whom are designated persons permanently bound to secrecy because of our access to what is designated under that act as special operational information, which prohibits disclosure of information which could reveal
So would it be correct to say that except for the specific provisions in the CSE Act and the CSIS Act, the other constraints and rules apply equally to both CSIS, CSE, and the other agencies within the intelligence community in Canada?
Yes, I would say that's correct.
And now, Mr. Rogers, you spoke briefly about the structure of PCO and its role in the intelligence community. But could you please describe a bit further details PCO's place in this structure?
Yes, of course. PCO, as I mentioned earlier, is not a collector of intelligence in the way that my colleagues represent agencies for. We are consumers of intelligence, and we do produce intelligence products, primarily through the Intelligence Assessment Secretariat, but those products are assessments of intelligence that comes to us and is not collected by us. Those products rely on information provided by CSIS, CSE, other government agencies and departments, and foreign partners, typically through CSIS and CSE or other government departments. And we respect the same rules that the originators of that information apply, including the classification and the handling procedures. So because we have not originated that information within PCO, according to the policies that we have established within the government, we respect the rules that CISA, CSE, or others would put on that information, including with respect to further disclosure and handling. Most of that is described under the policy on government security that David mentioned earlier, which is approved by the Treasury Board. Like David and Alia have stated about their employees, the employees in PCO who work with the most sensitive intelligence are also permanently bound to secrecy under the Security of Information Act. That's because they handle maybe not the raw operational details or the sensitive details of the ongoing operations that CSE and CSIS and others will have, but they will benefit from very classified documents that are the results of those operations. And sometimes, when necessary, we will participate in the coordination discussion of those operations. So very similar prohibitions on our staff with respect to the disclosure of information, and I think that's mostly it for us. I would maybe just reiterate that the volume of information produced by the Intelligence Assessment Secretariat is typically lower than that of CSE and CSIS. We produce intelligence. It's a much smaller secretariat within the Privy Council office. Thank you.
And does the National Security and Intelligence Advisor or any other PCO office have any role in developing, coordinating the government or any agency policies and procedures on the protection of national security? Is it a function that PCO plays?
Formally, policies like the policy on government security that was referenced earlier, these are policies that are approved by the Treasury Board and apply to public servants broadly. That's not a PCO role to create those policies and approve them. Of course, we have input into those policies, as other government departments have, as they're consulted and developed. And we do coordinate sometimes the national security community around the application of those policies when necessary. But no, we don't have a formal role in approving those policies, including the National Security Advisor.
And does PCO or the NSIA have a role in decisions that, for example, CSIS is making concerning disclosures of information?
I will answer. I should say, as David mentioned earlier, PCO does have a role in convening cabinet business and preparing cabinet. So things like the intelligence priorities, for instance, which does guide the work and prioritize the work of the whole intelligence community. PCO does have a role in that. So it's not formally a policy, but because this is something that is approved by cabinet, PCO has a role in preparing that for cabinet and for facilitating its discussion and approval at cabinet and conveying those results to other departments and agencies. To your question, I'm sorry, could you repeat your question?
Well, is there a role for PCO or the NSIA in developing, coordinating, or administering within government or within any agency policies and procedures on the protection of national security? But you mentioned that the Treasury Board policy applies to classification and access to information, and I understand that PCO plays a role at convening the community and conveying cabinet orientations.
Yes, and I will say, those policies apply equally to PCO staff, so we implement them just as well as other policies and departments, and we respect those policies within the Privy Council office. I think you had asked about whether we, direct other agencies in the application of those policies, and the answer is no. Departments and agencies are accountable to their own deputy heads, and they oversee the application of those policies within their departments and agencies. PCO does, as mentioned, have a role in convening if there are, for instance, issues that affect more than one department or agency that require a community discussion. PCO can convene those departments and agencies. We can challenge the various positions and try and help the government community come to a consensus and a way forward when there are complex issues. But at the end of the day, the accountability rests with the appropriate deputy or agency head.
Donc, Monsieur Vignon, on en a parlé un peu tout à l'heure.
Question, Mr. Vignon. Earlier, we talked a bit about this, and even yesterday, we discussed yesterday with the former agency reps, with the interactions between CCs and CSE. Could you explain to us the relationship between these two agencies? Answer. As I said before, it's important to understand the nature of the intelligence needs, particularly the nature of the threat in Canada, be it here in Canada or abroad. The mandates, the specific mandates of the agencies are executed specifically. They are reviewed by the review agencies. We make sure that we respect the rules, we learn them, and we improve every day. But concretely, the mandate of CSE and that of signals intelligence is essential for us. They have the capabilities, they have the mandate, they have partnerships that enable them to go get information that is essential. And the interactions are at the highest level between myself and the head of CSE. So at all levels, our operational chiefs, our working teams work together on technical issues or on thematic issues like counter-espionage, terrorism, foreign interference. So they have interactions regularly, sometimes every day, to be able to properly understand what is happening and to look at the information we have, looking at the nature of the intelligence and the threat. Well, there are things we can understand as we learn. It could take weeks, months, years. Things like foreign interference, these are not things that we can work on overnight. CSIS has been working on these issues since it was established. So there are things we are able to accumulate information on. We perfect our analysis. We work with others who do their work on the matter. But for things that require rapid intervention, for things like that, there are interactions. CSIS can have some information that require quick action. When we talk about 24 hours a day, 7 days a week, I can assure you that that's how our agencies work together, 24 hours a day, 7 days a week. CSIS is present in all provinces in Canada. And throughout the world, we also have representatives, liaison and operational agents throughout the world. So sometimes we need to share information quickly to help CSE to carry out its mandate and vice versa. So this relationship is very critical in the context we find ourselves in. Question. Thank you. From the very beginning, we've been talking generally. So now we'll be getting down to the intelligence products that you generate. And related to the last question I put to you, could you explain to us the intelligence products that CSIS generates during its activities? And when you answer the question, please be more specific when you explain the impact of the relationship you have, for example, with CSE. What impact can it have on the contents of your products? Answer. The basic products that CSIS produces are what we refer to as raw intelligence, raw information. The information that our agents will be able to collect. So generally, we produce a report that is contained in a specific piece of information. There is no specific contextual analysis. It's general. So this is really the raw intelligence. So this information is shared throughout the Canadian government with people who have the necessary security clearances and who need to know the need-to-know principle. In English, it's called the CSIS Intelligence Report. This is a basic tool that is produced at CSIS. To be able to produce such a report, of course, we need a lot more information. We need more information that is essential, but there is no intelligence value added to it. For example, all information that may enable us to properly understand how an investigation is going on and what are the operational modes and things like that. Because the information we collect is not what we'll place in an intelligence product. It may have no value for someone outside CSIS. So CSIS produces a report that has an intelligence value. This report is a basis of what we do. Question from the Commissioner. So this is minimum information to determine what is useful or not. Answer, yes. So we are talking about the mandate to inform the government and to seek advice, and that is where analysis comes into play. We have specialists on various intelligence topics, various intelligence techniques. So an analysis report enables us to understand the information that was collected by CSIS. There's a few reports or a dozen reports. These may be talking about the relationship we have with some partners. We try to get signals intelligence produced by CSE. This could also be reports on information produced by our foreign partners that come directly to CSIS or shared with a CSE partners, and that is subsequently shared with us by CSE. So this is not open source information. These are analysis of information that is accessible to everyone, that could be accessible to everyone, but we use specific techniques that are not necessarily referenced in Google or on other online platforms. These various information sources allow experts with their colleagues to be able to carry out an analysis. Let's take the example of foreign interference. We will say this is an analysis of the different actors that are engaged in foreign interference in Canada. This could be a shorter or longer analysis. It could be a more specific analysis. But this analysis allows the reader, someone from the federal government with a right security clearance who needs to know, to respond to a specific question. And this provides a perspective on an issue to help the person understand the nature of the threat and the nature of the stakes involved, and this enables the person to take decisions according to their level of expertise. So generally speaking, there are products that are intelligence memos that are sent to ministers, multimedia products that could be used for specific briefings. But these products that I've mentioned are the basic products that arise from CSIS. Question. So for such products, who decides on the level of classification? Answer. The way we work is that the authors of this report, the analysts who produce the reports, well, as we collect, the way we collect information is that the information is such that it already enjoys a certain level of protection. If it's information that we produce ourselves, depending on the nature, depending on the sensibility of the source, the information would have already been pre-classified as secret or top secret. And this is with information that we produce. Now, for information we receive from our partners, as I said before, this is information that they control. They produce the information. They understand the risks involved if the information were to become public. Generally, this information could be classified secret, top secret, or even a higher level of secrecy if we are talking about signals intelligence, for example. So the information may have been produced by another agency It is reviewed by the author. So the document should be classified at the highest level, always. If it's 90% secret, there could be 2 or 3 parts of the information that are produced secret, and if that's the case, it's classified as secret. So in that case, the author, the expert, is the one who determines the level of classification depending on what I said. Who determines the level of classification? Question, you talked about intelligence products that you generate, but are there intelligence products or products that CSIS generate that are destined for a public that is not classified, if I were to speak that way? Answer, absolutely. As I said before, the service mandate is very clear according to the law. The mandate is to inform the Canadian government, the federal government, and take mitigation measures. It's not necessarily a formal mandate in the law to share information, non-classified information with Canadians. That being said, in practice, and this is something we've been doing for the past few years, since 2015, and we've been doing so even more intensely over the past few years. We understand the nature of the expertise we have. We understand that we need to protect Canadians. So our ultimate goal is to protect Canadians. To be able to properly carry out that mandate, we must be able to share information. We must be able to share some of our knowledge, some of our observations with Canadians. So the need to share information is reflected in the documents that we write. There are specific documents, for example, which would be of interest to the Commission. They are called Foreign Interference and You. These are unclassified documents that are destined for Canadians, written in a language that is very accessible and that allows Canadians of all backgrounds to be able to better understand what foreign interference is all about and to know the types of measures they need to take to protect themselves. So this document is written in many languages and distributed, of course, available online and distributed to various communities. So we want to know that people are able to understand the documents. As a director, I deliver public addresses. I try to Anyways, we attend many parliamentary commissions, and over the past 2 or 3 years, we've increased significantly our commitment and provinces, territories, and municipalities to be able to talk about foreign interference, espionage, and so on.
So the speeches, publications, and other types of public appearances, what we try to do is to help Canadians understand and for us to understand that in order to increase our resilience to foreign interference, that there needs to be a certain level of transparency. But I believe that you've already discussed this issue.
Rogers, briefly, could you please explain for each of your agency and for PCO the intelligence products that you create and the audience for which product, and also not just the intelligence product per se, but also any other products that are generated for the public or for a non-classified disclosure?
Absolutely. I'll start first with our foreign signals intelligence side of things. So the main product that we produce is, again, for appropriately cleared members of the Canadian government and different government department clients, and that would be essentially a record of a particular communication or anything else that we have collected. So I would describe it, I think in the interview summary, I might have described it as a summary. I think a better word for it would be it's an accounting of what we've collected. So it's not a transcript, and it's not an analytical product, but it's a detailed accounting of what the information that we received was. And the reason that that it's so detailed is because we, unlike the service, we produce that intelligence for consumers to assess. So we do not do all source assessment within CSE. We produce this intelligence. We may add some context and analytical elements to help the reader understand that product, but it's destined for government clients who will then use that in conjunction with their needs. So that's one important distinction. We may also produce analytical summaries of our signals intelligence, and that would be to assist different clients. Some clients are not interested in the significant amount of detail we might provide, and they might want more of a summary or more of something at a higher level. So we would do that as well. But in terms of the other aspect of our mandate in terms of cybersecurity and cyber defense, I think it's really important to mention that we do have a host of additional products that we would do on that side, and that those are to inform clients of cybersecurity threats. We have a national cyber threat assessment that is conducted on an annual basis that is destined for the public. As I explained, part of what the Canadian Centre for Cybersecurity takes very seriously is the need to protect Canadians from cyber threats, and so informing Canadians is an important part of that aspect. And so we have the National Cyber Threat Assessment. The other main publication is what we produce on a biannual basis that we have ever since 2017, which is our Cyber Threats to the Democratic Processes report. One would have been released in December most recently. Again, that is to specifically describe the nature of the cyber threats as it relates to democratic institutions. That's also intended for the public as well. We do a host of, I would say on the Cyber Center, a host of advisories that they would either provide to government agencies or to industry, including those for Canadians that would speak about specific cyber threats and ways to mitigate those threats. So those are important products. And I think I'll highlight there a little bit the Cyber Center's relationship with industry partners is also an important one. So they will have products that will be specifically intended for particular industry groups let's say around critical infrastructure. Maybe they would be destined for the energy sector or the transportation sector. So they would produce tailored products for those industry-specific sectors. And lastly, I'll say CSE, as part of our act, is mandated to provide an annual report, which we do. The annual report describes all of the activities that are undertaken by CSE under the 5 aspects of our mandate, with a fair amount of detail in terms of what we see are the major trends and major threats affecting Canadians, and also an accounting of our activities and what our major activities were throughout that year. So I think that's also an important publication that we undertake on an annual basis.
Mr. Mackay, listening to my colleague, I realized that I forgot to mention 2 very important documents, 2 important reports. Le premier, c'est
The first one is our annual report, says Mr. Vigneault, same as my colleague mentioned for the CSE. So CSIS prepares a very detailed annual report on our activities. And in this report, there's a lot of information. And the audience is quite large, so I would invite you to consult the annual report. I know that we're talking about transparency, and there's a lot of information in that report. And once again, we're trying to understand what would be useful for Canadians. And we're trying to evolve not only in terms of the quality and quantity, yes, that of information that's in our annual report, but also we've also started to publish another report, and this is a report on foreign interference in democratic processes. Once again, Madam the Commissioner, I think what's important to remember about this, and I don't want to speak on behalf of my colleague, but I think it's applicable in her case as well, but at CSIS, when we write about espionage, terrorism, or foreign interference, and when we write about that in a public forum, it's written by people who have all of the security clearances required and have the expertise in that area. So they are able to produce a document that would be of interest to the public while respecting all portions of the Act. There are precedents that exist in this area, and it's the difference, for example, of a think tank report. And those we must make sure that all of the classified information is removed. Question. But that wouldn't be the situation with the think tank, because it would be a higher level report, and they may not. One thing that's evolving a lot is open source intelligence. In recent years, and allows certain comparisons between different aspects of that intelligence. So people who have access to no classified information, but who are experts in a specific area and are able to piece together intelligence, and they are able to produce reports of great value. So that's quite important, and I want to speak about that, or we will be speaking about that later when we talk about the type of information that is classified. So think tanks, yes, will have a higher level discussion, and they'll have a very specific analysis because they have access to open source data that perhaps the general public would not have access to. Question. I wanted to understand one thing that you mentioned. Earlier you said that the document is always classified at the highest level based on the content of that document. So, for example, if there is one sentence that's considered to be top secret, then the whole document will be classified top secret. But if there's a document produced by CSIS, am I right to understand that there's information from open source data, but also from other classified information and documents? And in that case, the document will be classified at the highest level of the classified information. Answer, yes, exactly. Question, so when we're So if a document only includes open source data, it will not be classified. Answer, yes, each document will have paragraphs, and there might be a level of security for each paragraph. So this would not take place in all of the documents. However, and maybe I'm skipping ahead here, but one of the things that's important to remember is that in a classified document, the open source information sometimes can be disclosed, and that can be harmful. It can be significantly harmful. So, for example, if a document deals with foreign interference from X country, there would be open source information, classified information. But if there's information that's open source that provides important information and that is disclosed, in that case, it provides the other parties, the adverse parties, of what we know. So, for example, if we're talking about a specific geographical area, well, in the context of a classified document, the disclosure of the open source data or information could be harmful, and this precedent was recognized by the courts.
Take the morning break. There's one question I'd like to ask to all of our witnesses. You mentioned here and there during your previous answers the need to know principle, and there are controls to the access of information. So I'd like to hear you about those controls and also the levels of harm associated to the different levels of classification. So secret, top secret, protected. So there are a couple of topics in my question, but if you could briefly, in 2-3 minutes, provide some guidance on those questions.
Sorry, that's for me?
For all of you, whoever wants to.
I mean, did you want to start off, Dan?
Sure, I can start off.
Levels, and then we can add the additional.
Yeah, that's fine. So certainly, yes, all of us in government who have access to classified information respect something, as you referred to, as the need to know principle. And this is really a principle that tries to ensure that the information that is sensitive is kept to those who need that information to be able to do their work, to minimize the risk of accidental or inadvertent disclosure of that information. So the principle being, if the information only goes where it needs to go, the risks associated with the disclosure of that information are lower. That applies at all levels of protection and of classification of information. But of course, as you mentioned, there are different levels of classification within the government. This was something described in, I forget the number of the document which you referred to earlier, but broadly speaking, the government policy speaks to something called protected information. Protected information has 3 categories: protected A, B, and C. And those categories relate to information that, if revealed, would be injurious to something that's not a national interest. So this would be something relating to an individual or an organization. Protected A information, you'll forgive me if the wording isn't exactly right, would reveal an injury or would cause an injury if revealed. B information would cause a serious injury, and I think protected C information would cause an extremely grave injury to a person or organization or entity at the non-national level. Classified information, which we tend to speak about more, is at the confidential, secret, and top secret levels. Those levels, similar to the protected levels, are about the possibility of an injury, or would cause an injury, a serious injury, or an extremely grave injury, respectively, to the national interest in that case. And so that framework applies to all of us and all other departments and agencies within the federal government, and the need to know principle is applied across all of those. As a small addendum, beyond the top secret level, and sometimes below, there are control systems applied more formally than need to know to certain types of information. For instance, there are control systems that apply to signals intelligence, which my colleague could speak to, and other forms of control systems beyond top secret that formally limit the disclosure of information up to and including named distribution lists on individual products.
So I could add on to that. From a signals intelligence perspective, as designated in our Act and also in the Policy on Government Security, CSE is the national authority for signals intelligence. So in so doing, we develop a classification system and standards as it relates to signals intelligence. The designation for us is SI, or Special Intelligence, and so you may see classified information with an SI control on it, which would mean that is signals intelligence. We administer a special indoctrination process, which would be applied to provide access to for somebody to information that's designated in addition to its classification, that it's controlled by SI. And so we administer Canadian SIGINT security standards at CSE and provide those to the rest of government so that government can also ensure that they maintain those standards. I think beyond that, you alluded to a sub-control system. There might be additional classification on a document, a sub-control in relation to the SI designation, again, administered by us, would include, we have 2 control systems or sub-control systems, which would be gamma material, which we might find on some of the material that's been provided to the Commission. That entails information that would be particularly sensitive techniques that might have been used for collection. And also we have another control system called exceptionally compartmentalized information, which would again speak to specific techniques. As Dan alluded to, the basis of this is really the need to know principle. So these are additional controls that are used to limit the amount of people who may receive this product or be privy to those collection techniques or capabilities, only to those who would need to have that information. So the classification stands, as Dan described. The control systems further limit the amount of information that is received by people who have a need to know, and that is also really it's documented. So we keep careful records of who has access to those controls or subcompartments, and we maintain those within CSE as well.
Thank you.
Mes collègues ont très bien décrit.
New speaker, Mr. Vignon. My colleagues did a good job at describing the situation. Question, yes, could you be quick, please? Answer from Mr. Vignon. The need-to-know principle in certain cases when we're talking about specific individuals or extremely sensitive information. Well, we're speaking here about specific people who had been designated, and that would mean that there might be 5, 6, or 10 people within the government who had access to that. So on this need-to-know principle, it could be that we're speaking about a very limited number of people. Comment from the lawyer. We will take a break, and it's almost 11:20, so we will return at 11:40.
Order, please. Alors, s'il vous plaît, the hearing is now in recess until 11:40. La séance est en pause pour 11h40. Commission will be commencing shortly. La commission commencera sous peu. Order, please. À l'ordre, s'il vous plaît. This sitting of the Foreign Interference Commission is back in session. Cette séance de la Commission sur l'ingérence étrangère est à repris.
You can go on.
Thank you. Good morning, panel. Gordon Cameron again for Commission Counsel. I want to pick up where Maître Mackay left off and talk briefly, because we have a fair bit to cover before the lunch break. So if you could just explain, this is probably most applicable to you, Mr. Vigneault, and you, Ms. Thieb, about the legal disclosure branches or departments within your respective agencies, roughly what their job is, what type of a manpower commitment it is, and how they work, in just a few minutes. Thanks.
Yes, so at CSIS we have a Director General who is in charge of the legal disclosure branch that encompasses the people responsible to administer the access to information and privacy legislation. Also the people who are the experts looking at the disclosure of CSIS documents for any other proceedings. So if we have court proceedings, if we have, of course, the inquiry and so on, whatever document that would have to be disclosed to an entity where classified information will have to be protected. In the case of the, when it's a judicial proceeding, there's also, it's not just to protect the information, but it's also to understand the impact on the court proceeding in terms of different accountability or Stinchcombe disclosure proceedings and so on. So these are the experts, and so we have centralized this unit, centralized this work in this unit. And I don't have, at top of my head, a rough order of magnitude, but these are, again, overseen by an executive at CSIS who are looking at the full gamut of the disclosure.
And Ms. Tabb?
Yes, absolutely. We also have a senior executive responsible for our program. In our case, I have a deputy chief colleague who is responsible for what we call authorities, compliance, and transparency. And so that deputy chief is responsible for a host of programs that I think you're referring to, one of which, as David mentioned, is administration of our access to information and privacy requirements. Any time that CSE information might be involved in the legal proceedings, we have a legal disclosures section as well. This same group of individuals will also be responsible for working with our review bodies. So in this case, National Security Intelligence Committee of Parliamentarians and our National Security Intelligence Review Agency colleagues, so that they would work with those agencies as well, make sure that they have the information that they require to do their work. They're also responsible for internal compliance, and they're also responsible for any requests that we might receive for what we would call sanitization or declassification requests, which may come in from various partners who may be requesting that particular CSE information be either reduced in classification, we would call it sanitization, or declassified to render any particular information declassified. So those are the responsibilities of that section. They would administer all of those requirements with the same general principles, although some of those requirements are slightly different. The principles of protecting national security information, classified information is part of each of their responsibilities. Like David, I can't maybe comment on the exact size of this group, but their work is extremely important. They're highly specialized and highly trained individuals in their work, so they're meeting all of those requirements on behalf of the organization.
Thank you. And if I could take you, I'll ask the question, and if you want, we can have reference to your institutional report where it's described in detail. And indeed, we would invite the participants to have reference to the institutional report where the point I'm now going to ask some questions on is set out in considerable detail, and that is your institutional report addresses a section on how the agencies will respond to requests from the Commission for further disclosure of information in classified documents. And it describes a fairly detailed process beginning on page 17 of the document. Perhaps I'll ask the court operator to bring up the institutional report. I'll work with the English version, which is Doc 3. And we can go to page 17 of that document when we get it up on the screen. If you can scroll down a little further in the page. Your page 17 isn't the same as, there we go. Okay. It looks like it's a PDF, page 18, the document's page 17 at the bottom, the heading internal process when commission questions / challenges a redaction. And you, in this section of the institutional report, set out quite a detailed set of stages that your agencies will go through. And I wonder if you could just, as I say, we have the document here, so you don't need to repeat it, but if you can just describe generally how your agencies will respond to requests from the Commission when you've sent us a document with redactions and we say, can you look again at such and such redaction? Can you consider this potential summary of a redaction? or perhaps a total lift, how would your agencies run it through this process?
So if you allow me, Mr. Cameron, I would say that it's important that this specific procedure that is described in this document is a tailored procedure for the Commission. It is the government's position, because of the nature and the mandate of the inquiry, to be able to bring as much information to the public. That's why these procedures have been put in place. And so I think it's important to remember that this is the intent that, we bring to the Commission, is to be able to be as transparent as possible within the limitations that exist. And so with that context, the way it would work is that, again, as we have described, we have specialized units that are, we have experts in understanding what are the specific legislation, the specific requirements to protect information. And so they're the ones who are able to do the initial triage. These experts on how the information needs to be processed will then refer to experts of the subject. So subject matter experts, for example, for the work of the Commission. So the people who are at CSIS working on foreign interference, so these are the ones who know specifically how these documents have been produced, where is the specific information coming from. So the people who do the work of redaction will then talk to these experts. And that's will be the way that as much information as possible is then make available. If there is a conflict, or if there are challenges or issues, then there is an escalation process to go to a more senior executive in the organization with more experience, who may look at it from a strategic point of view, and ultimately it comes to the head of the agency. In the case of CSIS, it'll be myself to make a final determination.
Likewise, similarly, just to echo what David said, that this is not, just to clarify, this is not the normal procedure that we would adopt with our normal practices, but given the importance of the inquiry, this special mechanism was devised, and that terms of reference allow for different methods of trying to achieve the objectives. And so this is what is described here is these alternative methods. So, but like David, we will have subject matter experts who will take a look at it. They will provide an explanation of why the redactions were provided. It will escalate in here in the document. It says it would escalate because of the level of importance. So to the assistant deputy minister level, which in CSE's case would be myself, for consideration as to what are the other alternatives for achieving the purpose that the Commission is seeking, which is a particular piece of information that you've found important or relevant to communicate. And so what other options are there? So what additional analysis can be done? Do we need to seek additional permissions, or could we avail ourselves of the options to write a summary that could best describe the information without revealing classified sources or methods?
Thank you, and I will ask this of you, Mr. Vignon, and you, Ms. Tabb, but in particular, Mr. Rogers, if you can give the PCO perspective too, because the question is, would there be occasions when this process, which doesn't explicitly in the institutional report refer to consultation with the PCO, but are there times when the process could involve consultation by your departments with PCO about a potential disclosure?
I think as Dan described, PCO may serve as a convening function if there are issues at dispute or where issues touch numerous departments. It might be helpful in some cases if there's a particular piece of information that we share or that we have both joint interest in, that we discuss together how that could be achieved or how the result could be achieved. And PCO may, in that case, assist in convening, particularly where there are multiple departments with interests. That's one example where I could see that occurring. But
maybe just to add, I would say that I'm sure my dear colleague here would never hesitate to convene us. Based on experience, I would say that I fully expect the practice for the next number of weeks and months of this commission will be that there will be very regular discussions amongst agencies in the Privy Council office. Fully expect this to be the practice.
And Mr. Rogers?
Well, I certainly agree with my colleagues. I do expect PCO to be involved. I would note a couple of points. One, which I've mentioned earlier, PCO, while we convene, and during those times when we convene departments and agencies, should there be disagreement about the way forward, we will seek to challenge positions, refine positions, and come to a consensus. The ultimate decision still rests, as Mr. Vignon and Ms. Tayeb said, with the agency heads and the departmental heads who own the particular piece of information. But it is definitely our role to convene and discuss when there are strategic issues and when there are multiple departments and agencies involved.
And probably particularly when the PCO is involved, or perhaps even when it's an agency matter, would there be a point at which there could be political input from this with respect to the government's interest in transparency on a point that might assist your department or the PCO or the agencies in coming to a decision on a potential disclosure?
In this context, the government has set out its expectations, I think, fairly clearly in the terms of reference for the inquiry, and we've established the processes that we will be undertaking to produce these documents and come to these results. So I think that, as described here, the deputy heads of the agencies will come to decisions on redactions, and the process will really be a non-political one as we allow the expertise to render these decisions.
Okay, if we could move now, I'm going to talk a bit about the what I think we've all come to understand as the 13 documents, and for the benefit of participants or members of the public who haven't followed each of the stages by which we got here, these are the 13 documents that the Commission provided to the government on a sort of sample basis to see what we could expect in terms of disclosure of classified information in the documentation, the first tranches of documentation that we'd received. They came back with a letter from the Department of Justice dated December 15th, which is, you will find both as a tab to the institutional report and as a freestanding exhibit in these proceedings, that explained, the December 15th letter explained the rationale for the redaction. So with that context in mind, I note that the covering letter, the December 15th letter, in returning the redacted versions of those documents, so the Commission had the unredacted and asked that they be redacted for public disclosure. The letter back observed that it had taken 200 person hours to get through those 13 documents. Can you help put that what might be seen as a quite exceptional amount of work, how that was required for 13 documents, most of which were just a few pages long?
I can comment on that briefly, and then my colleagues may wish to add more. Certainly, it's true that the experts and others will have to spend time analyzing the specific details of documents like the 13 that you've provided, or that we have provided in redacted form. That effort will scale up proportionally with the number of documents we have to redact, but also included in that letter was our suggestion that other mechanisms may be used to achieve the transparency goals of the Commission that we would be very interested to undertake, and that includes summaries and hearings. One of the challenges we have with redacted documents is we are starting from something already written that was intended to work in an ecosystem of cleared individuals in the national security community and not intended for public disclosure. So it includes a lot of details that need to be redacted. We may find better success with more efficiency in producing things like summaries and other types of documents.
So I think it's very important in the context, not just of those specific documents, but the inquiry itself. So these documents are product, a number of them, not all of them, but a number of them are CSIS intelligence products. So the Parliament of Canada has created CSIS to be able to collect information, produce intelligence. So the purpose of this, but these documents are meant, and as Dan mentioned, they were meant to be including classified information. Contrast that with the what Alia and I mentioned earlier, the types of documents we've produced. We have produced for public consumption very highly relevant documents on foreign interference, on espionage, on terrorism, on geopolitical considerations, affecting the national security. All of these documents have been written for the public, again, with the insight and the knowledge of the classified information. And that's why there is such a contrast in a public document that is meant for public release, and then those documents that have been released produced with an entire, completely different purpose in mind, and they were full of classified information. That's why when you show these documents, people will see the amount of information that has been blocked out for release. Some of these documents are completely blacked out because they were meant to be full of classified information for people with a security clearance. They were not meant to but the same topics, and I think this is what Dan mentioned, and the government's position coming into this commission of inquiry was to say there is a way to have transparency and to engage the public with very specific information. And this is what has been laid out in terms of how to produce redacted documents, possibly, how to produce summaries of highly classified documents, but in a way that you protect those specific details, but you can still inform the public. So I think this is important to have those two paradigms in mind, if you want, something that was written at the classified level purely for the government's consumption with people with clearances and need to know, versus something that is meant to be a tool of transparency to engage and educate the Canadian population to increase its resilience.
Okay, go ahead.
Sure. I just thought I would add a bit to your question about level of effort, as maybe just to specify a bit for those who aren't engaged in the redaction process as part of their normal jobs. But I mentioned before, when we really do have folks who are experts in not only the manner in which we collect our information, but also in the jurisprudence in and around what is acceptable redactions based on the legal frameworks that we have at hand. So that is what is applied for redactions, and the folks who do that are highly trained in that. Where it's laborious is that you're going through every line and you're applying redactions, but then, and some will be obvious, and then some will require analysis. Is this something that is known to the public or not already? And then they'll have to consult with a subject matter expert to say, can you help me understand perhaps whether this particular element can be revealed or not. So some parts will be very evident because it's a technique, it's a source, etc. But where we talk about investigative interest, or could it lend itself to revealing a technique of collection or a human source or a technical source in our case, then it does require additional analysis, which is why I just wanted to highlight that to explain why when we talk about the number of hours that it takes to do this, it's the analysts, it's the subject matter experts they would engage. There's an approval process that it would go through before being released. So there are quite a few steps involved in the redaction process.
Okay, well, on that point, there's nothing like looking at the document itself so that we can have something more concrete to talk about. If I could ask the court operator to call up CAN 900 and There we go. This is a report of the Critical Election Incident Public Protocol dated May 2020. And if I could just ask the court operator to scroll through this relatively quickly. And what we will observe, and I'll ask panel for you to observe, is that this document is either totally unredacted, or if there's a redaction in it, it must be very small. We note that just pause there, please, right there. We note that it is classified secret, so it started out its life as a document classified with the classification we know means the disclosure of this information or some of the information in this document could cause serious harm to the national interest. It went through the process we asked you to engage in, and as near as I can tell, it's totally unredacted. So in its publishable form, in its disclosable form. So Mr. Vignon, is this an example of a document that was written for a broader audience and is thus easier to lift and disclose more completely?
So this is not a CSIS document, but what I would say is that it speaks to the exchange the commissioner and I had earlier about some documents, will default to the IS classification because there are a few pieces of information, even though in this case, the overwhelming majority of the information would not be classified. And so this would be a good example of a document that could be, that was redacted and that, is now available to the public, even though there's a classification. I think and a lot of this was meant to explain, if you talk about the procedures that were in place, to look at so there were not pieces of intelligence of classified information that were the purpose of that document. When we contrast this with other documents, which I assume you Mr. Cameron, will produce or will show, we'll see the difference where, a document was meant for a very, very different purpose.
Let's do that. Perhaps the court operator, for purposes of exactly that contrast, Mr. Vignon, could call up CAN 5847, which is a CSIS intelligence report. So that much was unredacted. We understand what the intelligence product was, and yet, other than its classification and the page numbers, it appears to be pretty much completely redacted. And so I take it this would be one of those documents in the category that was written for a different audience.
Absolutely. So as I mentioned this morning, CSIS intelligence report is information that has been collected by CSIS that would be with just a little bit contextualized, but this is raw intelligence. So it is something that contains all of the classification, the classified information, and it is meant to be sharing intelligence specifically, not the full analysis, but the intelligence with some very specific people inside the federal government, as per the CSIS Act, is mandating us to do. And so that's why here is a good example of a top secret document that, will be, in this case, fully redacted. The exercise, what is of interest is that, again, this is a raw intelligence product. So it's the information produced and essentially shared with people. This is something we know. If you contrast with other documents that I talked about this morning, intelligence assessment, where it takes CSIS information, CSC information, and other partner information, potentially open source information, and tries to provide a picture, you might see a different approach. But the biggest distinction is that the same topic, so if you're talking foreign interference by country X, you could have a CSIS intelligence report that will be completely blacked out. And you could also have a document that can be produced with the intent to be released. And so you can talk about the same topic in a public format that will essentially provide a level of information. But of course, that will be protecting the information that we are mandated by law to protect.
Well, let's do exactly as you described. We've just looked at a CSIS intelligence report, which is pretty much fully redacted. And let's look at a CSIS intelligence assessment. If the operator could pull up CAN 5784. This is the type of document with which you were contrasting a report. Now, again, if the operator could just scroll through, we will see that though this does operate perhaps at a different level than the intelligence report, it did, not much got through other than the description of the United Front Work Department. Can you I guess, make any observation other than that the information that is redacted had to remain classified?
Yeah, so as I mentioned, the distinction is when you are writing a report with the intention of this report to be read by people with security clearances and need to know, you try to be as precise and as direct with the facts that are important. In the case of an analysis, then you add your perspective. The expert analyst will add his or her perspective to it. And so some of these analyses might be, other versions of a CSIS and intelligence analysis report. There might have been more information released. In this case, there's very little. Madame la Commissaire, si vous regardez la boîte.
Madam Commissioner, if you look at the box to the right.
An example where we have unclassified information, which releasing it would not be in public, would not be injurious to the national interest. And that's why this information is there. In other contexts, it's possible that, referencing something that even may not be classified, in this case, because it's related to China, Chinese intelligence services would be able to make a deduction and be able to make analysis of what we know, what we're interested in. And this is the root of why we are protecting information.
Okay, that's helpful. And you mentioned that there could be variability amongst the amount of redaction in an intelligence assessment. And we have an example of that. If the operator could pull up CAN 5811. So here we have another intelligence assessment, but as a reader will observe, a lot more of the content of this intelligence assessment has made it into the public realm. And again, if the operator could just scroll through that and we'll get an overview. And I think, Mr. Vignon, you've already explained how it could be that sometimes information can be disclosed and sometimes it can't. But what we have here, we've seen now 2 intelligence assessments produced by CSIS, one of which ended up having to be highly redacted and the other of which is fairly lightly or surgically redacted. And maybe you could put those 2 reports in the context of the comments you've been making.
I think this is actually a very, very useful exercise. The previous intelligence assessment, which was almost completely redacted, versus this one, which is the highest classification. The document is classified top secret because that's the highest classification of the document. And if the operator can scroll up a little bit, you will see that after that exercise that CSIS experts did to review the specific document, you have, if you scroll, that's fine, sorry. You have, in this page, you see that you have even a paragraph that is marked top secret that has been released. And the reason for that, and I think it's something that is very important, Madame la Commissaire, pour le travail de la commission. Some of that was classified top secret at a specific moment in time. This document was produced in 2021. And with passage of time, the information has evolved, and more information has become public, and the injury is different in 2024 or 2023 December when this was produced. And so that's why you see a paragraph that is marked top secret has been released. And I think it's important for the rest of the commission, the work of the commission, to see that temporality has also an impact. And your point earlier, Mr. Cameron, about the amount of time it takes. So this is, I think, a good example that is not just the institution just saying it's a top secret document, it's going to be completely blacked out and nothing will be released. So experts have gone line by line to review it. And then say even something that was top secret, with the passage of time, the understanding of where we are and the injury to the national interest that would occur if this was to be public, you can still have information there. So I think it is a good example of the professionalism that the experts are applying to this. But again, as you mentioned, as the council mentioned, 13 documents required about 200 people hours to be able to produce that, which is a very significant amount of resources. And last thing I would say is that the experts, the subject matter experts, so in this case, it would be experts on foreign interference and Chinese espionage activities and so on. These are the same people who right now are engaged in collecting information, producing intelligence that is protecting Canadians today in 2024. So they are being taken away from doing that work to be doing this because it's extremely important. But I think it's a consideration that I think is important for to be able to share with the Commission.
Just a detail I see just beside the secret Canadian eyes only. Can you just expand a little bit on what it means in the context of classification?
Yes, so Canadian eyes only means that it is information that in this case would be either produced by CSIS, so let me rephrase, it's either information that has been collected by a Canadian agency that for reason of the national interest we would not be sharing with others, or the analysis of that information, which could come from information gleaned from other international partners as well. But our analysis takes into account the interest and the considerations that are important to the government of Canada, and we would not want to reveal that to another party.
I see. Thank you.
Okay, and for my last question panel, if I could ask the operator to pull up CanDoc 1 again, that's the, sorry, wrong, CanDoc 3, the institutional report. And scroll to page 12. And towards the bottom of the page, or I guess just above protecting information, there's a sentence, in determining whether to sanitize or declassify information, the originating agency has to weigh the public interest in making the information available against the risk and costs associated with disclosing the information. And just because we're running up to the end, I won't ask the operator to bring it up, but in the witness summary on page 13, I believe, with particular reference to CSE's contribution to that interview, there was a similar reference to balancing the public interest. And so in closing, the question for each or all of you is whether in considering the public interest in disclosure, your agencies and the government would take into consideration the fact that the disclosure would be for a public commission of inquiry on a topic of great importance to Canadians.
Sure, I can start on that. So I would say, of course, we are interested in ensuring we follow government direction as public servants to maximize transparency in the context of this inquiry. And that includes using all the available mechanisms, some of which we've outlined in the letter, to make information public where possible. What I would say is that also as public servants, our goal, is particularly in the mandate of CSE and CSIS and us in the national security community, is to keep Canadians safe. And so that balance is very important. If information is withheld, it is withheld because it is necessary to keep operations ongoing that Canadians rely on for their safety and security. So yes, I think the answer is yes. We do want to look at this commission and the processes differently. We are looking to suggest methods like summarization, like in-camera hearings and transcripts to maximize the amount of transparency. And I think those are examples of how we see this differently. But, you know, at the end of the day, there will still be information which is necessary to preserve as secret to enable the ongoing operations of the national security community.
Thank you.
Thanks. I absolutely agree with Dan's comment to that. I might just add a couple of things in this context, in the context of the interview, is I think the public interest is clear through the intent and the legislation that we enable. So for instance, access to information. The clear public intent is that people have ability to request information from government, or in a legal disclosure proceeding where there's a clear need to protect safety. So there might be a public interest in that regard to enable a prosecution. So the public interest is really defined by those mechanisms that require disclosure, to my mind. And so the Commission of Inquiry is an extension of that. The public interest has been defined in the terms of reference, that there is a clear public interest that Canadians understand the extent to which foreign interference in elections takes place, and that they have confidence in public institutions. So that is the public interest, and indeed that's what the standard that we apply in each of those processes. And I think, as Dan said, that's weighed, and as is reflected in the terms of reference as well, that there's a public interest in achieving this, and we will do this. And at the same time, we need to protect those classified sources and methods because we're legally bound to do so. So that's how I would maybe make that inference as well.
If I can maybe just foot-stomp what my colleagues have said, you know, this is clearly a different approach. It's a bespoke approach, tailored for the Commission with the mandate of making as much information public. It's not business as usual. The procedures that, you know, have been proposed by the government in terms of providing redacted versions and summaries to be able to provide that, I think is clear expression that this is, you know, the intent of the Commission of Inquiry to provide as much information to the public is clear. While we maintain the need, mandated or legislated need for secrecy for the different, to protect, you know, our ability to continue to work in the future, continue to protect Canadians. So I think the intent is very clear.
Thank you. That's been very helpful, Madam Commissioner. Those are all of my questions.
Okay, so we'll take the lunch and we'll come back at 1:55. Bon appétit.
Order, please. À l'ordre, s'il vous plaît. This hearing is in recess until 1:55. La séance est maintenant en pause jusqu'à 1h55. The Commission will be commencing shortly. La Commission commencera sous peu. Order, please. À l'ordre, s'il vous plaît. The sitting of the Foreign Interference Commission is back in session. Cette séance de la Commission sur l'ingérence étrangère a repris.
Just trying to. So good afternoon. We will begin the cross-examination this afternoon. I would like just to remind all the councils one rule that we have established, and it's not a complaint. We are all learning and we are getting used to the rules. But if you intend to use any documents in the cross-examination, you are required to provide the document to the Commission 3 days in advance. And the idea is not to pose any obstacle to the cross-examination or to make it difficult. It's because we have a database that needs to be uploaded, and it takes time, especially when we are receiving a lot of documents. So the risk, if you wait, is that the documents won't be in the database for your cross-examination. We did our best for today, but by chance we are at the beginning, so there was not too many documents, but just make sure to take the habit to send the documents 3 days in advance, please. So the first, I just want to make sure I have the proper list. It was on my seat, but I mixed up everything. Thank you. Okay, the first cross-examination will be conducted by two lawyers, actually, John Matter and Michael Robson, for the Center for Free Expression. I'm also taking this opportunity to remind you to identify yourself and to repeat. I know that you did that on the first day, but to repeat who you do represent, please, for the benefit of everyone in the room, including the witnesses. Thank you.
Good afternoon, Commissioner. Good afternoon, members of the panel. My name is John Mather. I represent the Center for Free Expression. The CFE is a non-profit advocacy and education organization based out of the Toronto Metropolitan University. In the interest of time and efficiency this afternoon, my questions will primarily be for Mr. Vigneault. I trust that Ms. Taib and Mr. Roger won't take any offense to that. I have about 10 minutes of questions, following which I'm going to cede the podium to my colleague, Michael Robson, who will then have some questions about the 13 documents that have been produced through this process so far. So, Mr. Vigneault, I'm not sure if you've been able to follow the proceedings so far this week, but the Commission has had the benefit from hearing from experts on issues of national security confidentiality and public disclosure. The experts included individuals such as Richard Fadden and Alan Jones. I assume you're familiar with those two gentlemen.
I am.
And one of the reasons the Commission has convened these hearings is because one of its mandates is to maximize transparency. And I take it from your answers this morning, you're well aware that that's one of the Commission's mandates.
I am.
And hearing from the experts this week, I would say there's been consensus on several points, and I'm not going to put them all to you, but I have a few of the points of consensus that I want to see if you agree with. First, I take it that you would agree that foreign interference is a real and serious threat to Canadian society?
I do agree, and as a matter of fact, I've been speaking publicly about these issues since 2018 to address the need for what I refer to as a sunlight policy on the notion of foreign interference. Because as much as in a democratic society, you need to have an organization like CSIS or CSC to be providing classified intelligence and ability for the government to intervene, you cannot deal with foreign interference without having a society that is more resilient. And so that's why we've been engaging in dialogue and transparency with Canadians on this issue.
Thank you, Mr. Vigneault. And at this point, I'm just asking to see if you agree with them, and I want to give you the opportunity to provide any qualifying comments, but I will say I have limited time, so if you're able to say yes or no, I'd appreciate it, but I'm not trying to limit what you say. The second proposition is, or the second point of consensus is that, and I think you already touched on this morning, is that foreign interference in elections is a matter of utmost public interest. Do you agree with that?
I do agree with that.
Yeah. And the third and next point of consensus is that this commission faces serious challenges in fulfilling its mandate to maximize transparency because much of the relevant information is classified. Again, I think that's obvious.
I agree with that statement, yes.
And then again, a fourth point of consensus would be that the commission's timelines are short and the process for review of classified documents for public disclosure is going to have to be condensed. You agree with that?
I would agree with the fact that the timelines are short. I'm not sure I have an opinion necessarily on the latter part of your point.
It's fine. And then the last point I wanted to see if you agreed with is that we've heard from multiple of the experts that when the various departments within the federal government review documents for classification, they have a tendency to overclaim for national security privilege. Would you agree with that?
I have a different experience than that, and this is one of the area, Council, I cannot just answer yes or no, because it is more nuanced. My experience has been that there's been an evolution over time. What we were saying publicly, how we were engaging in these discussions in 2015, 2018 is not what it is in 2024. And it speaks to the amount of information we make public, the specificity of that information, and the regularity at which we are engaging with the public on these issues.
So let me put it to you this way. When Richard Fadden, the former CSIS director, says that there is room for the commissioner to push back on national security confidentiality claims, do you agree there is that room?
I would agree with the fact that the commissioner has agreed to the terms of reference, and these are the terms of reference that we all are abiding by, and are going to be doing our utmost to support the commission with this very important goal of engaging the public on this issue.
I think Mr. Fadden's point was really that when you look at some of the documents we saw this morning with the boxes of redactions, that it may very well be the case that there are things that have been redacted that on second thought ought not to be redacted. Do you agree that's at least possible?
I have not had the opportunity to listen to Mr. Fadden's testimony. I can tell you, I'll repeat what I said this morning. Experts reviewed each and every line of these documents, people with expertise on redactions, and they consulted with people who have expertise in the subject matter. And I think we had good example this morning of, yes, some documents that were totally blacked out. Again, documents that were intelligence report was the sole purpose was to inform people with clearances. And when you contrast that with documents that were meant to inform the public, these documents were, of course, all in the open. So I think it is my experience is the way I just described it.
With Commission Counsel, you discussed this morning that really there's a fundamental issue here, which is the tension between the protection of national security interests and the public interest in the information about election interference. That's really what's come to a head when we talk about these issues. Do you think that's fair?
It is fair, but I think it's also important to note that there's not an inherent dichotomy between the public interest and the need to protect information. So you can have the public interest also includes the ability for the agencies like CSIS and CSE and others whose mandate by Parliament is to collect that information in order to protect Canadians. So it is definitely in the public interest that we're effective in doing our work. But the public interest also calls for, information to be, especially through this commission, and that's why those specific rules have been put in place. As I said, this is not business as usual. These are the rules that have been specifically put forward for the commission to make as much information public as possible.
And we've heard what you've said about the public interest in sort of, at times, keeping information confidential to protect Canadians. What I want to do now is bring some context to the public interest in Canadians having the ability to understand about election interference. And you understand that is its own form of public interest. Canadians have a right to know, and we'll talk about the limitations, but Canadians have a right to know when and what form of election interference occurred.
Yes.
Okay. And as I'm sure you're aware, the origins of this inquiry can be traced back to news reports from Global News and the Globe and Mail about allegations of foreign interference in Canadian elections. I take it you're familiar with those news reports?
I am.
And those reports described classified intelligence that had been leaked, that's correct?
Amongst other things, yes, but they were including many other parts, but yes.
Yes,
including
it wasn't the only thing in those reports, but there was reports of classified intelligence that had been leaked.
that were released were in an unauthorized way, yes, absolutely.
And some of that intelligence was attributed to CSIS?
Yes.
Okay. And I understand that when media reports on leaked CSIS if the media reports on leaked CSIS intelligence, the service can often not validate that intelligence when it's leaked. Is that correct?
That is correct.
Because doing so may reveal or tend to reveal classified information.
Absolutely.
Okay. And I take it then that one of the effects of that is that you can have instances where incorrect or incomplete allegations are put into the public record without clarification or correction.
I would say that what has happened and what we have seen and what is absolutely a danger when there is information of that nature that is put in the public domain without the proper context and proper explanation, there is the possibility of interpretation that may be factually incorrect.
Yes, yes. And I'm not going to review every allegation that was in those media reports. And Commissioner, my intent is not to go into the substance of these allegations, but rather to talk about what is in the public consciousness as we debate the public interest in weighing against national security. So to identify some of the allegations in those reports include that CSIS has had a dossier on Michael Chan's activities in the 2019 and 2020 elections, and that referred to him having meetings with Chinese intelligence operatives. That was something that was reported in those news articles, is that correct?
Commissioner, again, my understanding is that the purpose of the hearing today is to discuss the Part D of the inquiry, and I think, I'm concerned that we're going down the path here that is to get the substance of the issues.
So, Commissioner.
We won't.
Okay.
We won't.
And thank you, Commissioner.
I understand it's an introductory question, just to put it in context.
To put in context the public interest we're dealing with, I'm not going to ask you about the substance of that allegation. That's not my intention, at least. And that again, this is just whether this allegation was reported. It was reported that in certain instances, Chinese diplomats encouraged sympathetic political donors to provide campaign contributions to candidates preferred by China, and then a portion of those donations would then be returned to the donor. Again, do you understand that to be one of the allegations that was in the media?
Yes, exactly the way you framed it. That's one of the allegations that were in the media. Yes.
And if I don't say that in my question, that's the
Yes.
question I'm asking you.
Thank you.
And another allegation was that Liberal MP Han Dong secretly advised a PRC official to delay the release of 2 Canadians being held by China. Again, that was an allegation.
Yes.
Okay. And that Conservative MP Michael Chong and his family in China had been targeted by China. Again, that was one of the allegations.
Yes, I'm familiar with that.
And again, I'm not asking you to endorse or validate any of those allegations, but I take it you would agree with me that the public has a legitimate interest in knowing whether or not those allegations are true.
I think there is, this is the crux of the entire commission, Madame la Commissaire, of how to be able to take information that is in the public domain, that has not been validated, information that has been made, all of the classified intelligence that has been made available to the commission, and along the terms of reference, find the right way of being able to inform Canadians.
My question was a little bit simpler than that. Canadians have a legitimate and pressing public interest in knowing whether or not those serious allegations, and they're just allegations, but whether or not those serious allegations are true or can be substantiated.
Madame la Commissaire, my previous answer will stand for this answer, this question.
And you're aware that former Governor General, the Honorable David Johnston, conducted his own review of the allegations that were stated in those media articles?
Yes, I'm aware.
And through a different system, he was able to have access to the unleaked classified intelligence relating to those topics. Is that correct?
The commission, the independent special rapporteur was provided all classified information from all different government parties that were relevant to his mandate.
And after reviewing that information, Mr. Johnston came to the conclusion that when the individual pieces of intelligence that were reported in the media, when those were considered in the context of all the relevant intelligence, that the issues raised were either less concerning than the media had reported, or in some cases told a different story. That was Mr. Johnston's conclusion, correct?
Yes, I believe it was his conclusion, but again, I'm not here to testify about what Mr. Johnston's findings were or not.
Well, I'm going to ask you about one more of them and see if you at least are aware that this was his finding. That's my question really, is whether you know it. Mr. Johnston also stated that in order to understand the serious allegations that have been non-leaked materials carefully and in context. Are you aware that
the Right Honorable David Johnston came to his conclusion, eventually, if that's relevant for the commission, there should be no more evidence to say how having access to all classified information, but also being able to have some of that information written for release, which is one of the proposal that is been put forward by the government.
And so, Mr. Vigneault, when Mr. Johnston was talking about the necessary information he needed to review, that was my half of my time, Madam Commissioner. I am sorry for the alarm, and I'm going to go a little bit longer, so I apologize to Mr. Robson. We'll try to get through this as quickly as we can so we don't deprive him of his opportunity. But when Mr. Johnston, the information that Mr. Johnston said was necessary to review, which was the non-leaked classified information, that is still secret. He wasn't able to share that with the public.
Mr. Johnston, just to be very clear, Mr. Johnston had available, all of the classified intelligence that was in the disposal of the government of Canada that was relevant to his mandate. And so
Mr. Vigneault, no one wants to interrupt the CSIS director, trust me. But my question was really that the class, and maybe it may seem obvious to you, but the classified information that Mr. Johnson said was necessary for him to arrive at his conclusion, that information remains classified, correct?
There has been no declassification of information to that process. It was all of the information that was released publicly by Mr. Johnston was unclassified information. Some of that includes right for release reports that originate from very highly classified reports. Reports that if they were to have been released publicly would have caused extreme injury to the government of Canada and to the Canadian national interest. And that is the process that he has undertook.
Okay. So, Mr. Vigneault, would you agree that when it comes to a member of the public who was not in Mr. Johnson's position and was not in Commission Counsel's position or the Commissioner's position, if they want to draw conclusions on the serious allegations that have been reported in the media, they do not have access to the information that the former Governor General said was necessary in order to come to the right conclusions? Do you agree with that?
What I would say about this is that there is a distinction between the public interest to know and the ability of the government agencies to continue to perform their work every day to protect Canadians. That is at the core of the issue.
That's really not an answer to my question, Mr. Vigneault. I understand why you gave that explanation, but my question was, do you agree that Canadians who do not have top secret security clearance and aren't on the need to know basis do not have access to the information that former Governor General David Johnston said was necessary to understand the complete picture of those serious media allegations?
This is a true statement, but it is also important to say that the ability that Mr. Johnston had was to provide information to Canadians, to provide them with an account of what he was able to draw from these classified documents. And the Commission of Inquiry exists to be able to provide further information to Canadians, to provide further context as required to Canadians. And it is important to not always reduce these issues in a binary way. It is more complex, and this is why there is a very serious Commission of Inquiry underway about these issues.
Do you agree, Mr. Johnson, that Canadians do not, and let me preface this, we hear you and we understand the reasons that the government and CSIS is putting forward, but why it's not being disclosed. It's not that that's not being heard, but do you agree that because of those reasons, that Canadians do not have all the details they would need to have an informed discussion and debate on the serious issues that have been reported in the media?
My answer to that is that you can have an informed discussion, you can have a relevant discussion, you can have an important discussion with Canadians, by Canadians, not necessarily having all of the secrets in the public domain. There is a way to do that, and this is the challenge that we face in our community. This is why we are much more transparent. It's why we gave examples of documents that we have been producing for public release and for public discussion. And this is why the Commission of Inquiry exists, is to be able to provide as much information. But there is a notion here that is very important, is that the very notion of Canadians who want to be able to protect themselves by having information also rely on having agencies who can do their work effectively today and tomorrow. And this is why there is in our system, democratic system, there are rules and laws in place to protect classified information. And this is this balance that the Commission is going to have to address in the next number of months.
Do you disagree with Mr. Johnson that the information necessary to come to the conclusions about those allegations is classified information that cannot be disclosed?
Can you?
So Mr. Johnson's conclusion was you need to look at the classified information to come to a full picture and make an informed conclusion, or at least that's what he needed to do. Do you disagree with him that that information is necessary to come to those conclusions?
Mr. Johnston had a very specific mandate, and his mandate required him to look at the classified information. And that's why I believe he came to the conclusion that he needed to look at the classified information to be able to execute his mandate.
So, Madam Commissioner, those are my questions. If I may ask an indulgence for Mr. Robson, I did occupy a lot of our time, and he has been preparing to conduct these examinations.
Thank you.
Good afternoon, Madam Commissioner and the panel. I will try to be brief, as I'm aware that we have limited time today and limited time for cross-examination. I'd like to jump in immediately to some of the documents that were produced as part of the Commission's process, and in response to the request, the government produced 13 redacted documents. But before I do, one of the things that I'd just like to ask some general questions to sort of get us back into that mindset. So we heard this morning, and you would agree with me, that CSIS produces these reports that they produce to parliamentarians and cabinet ministers containing advice, intelligence, and summaries of what that intelligence contains. Is that correct?
No, that's not my testimony. I said that those CSIS documents containing classified intelligence are exclusively the purpose of the federal government, not parliamentarians. There's a very significant distinction. So people with the right security clearance and a need to know.
And I appreciate that clarification, but the reports themselves contain, in some cases, raw intelligence and also the summaries and analysis that have been performed by CSIS agents.
That is correct, but it's the audience that I think it's important that we clarify.
Absolutely. And those documents are often classified, and we heard this morning they can be classified at a certain level due to a single piece of information or maybe two pieces of information within that document.
That's correct.
And it's possible that if those pieces of information are redacted or sanitized, that document can be declassified or sanitized to a lower level of classification.
That's correct.
Court operator, I'd like to pull up document CAN 5780, please. And so this is a CSIS national security brief dated November 29th, 2019. And if we scroll down just a little bit, one of the things that is immediately apparent is that most of the information in this brief is redacted. And you can see that on the screen, correct?
Yes.
And this morning, I know we spoke about the reasons why it might be redacted, but I just want to clarify, when we're looking at these documents, the panel was speaking generally about the reasons why it might be redacted, not specifically for these documents in question.
That's correct.
And that's not why we're here today. Correct?
Yes.
But the only way to know what's in this document and to understand the reasons for the redactions would be to see an unredacted, a fully unredacted version of the document and to have somebody explain the reasons for why the redactions had been made.
Well, we are here to explain a part of that process, not those specific documents. But yes, did you want to?
Maybe just if I understood your question correctly, you said the only way to understand the contents of the document. I would argue that summarization and other forms of text describing what's under there are also possible in a way that doesn't reveal the injurious information.
But to ensure that those summaries were accurate to the information that's within the document, there would need to be somebody who had seen the fully unredacted document to confirm the accuracy of the summary.
Yes.
And this document itself, the one that's on the screen, if the court operator could scroll up just a little bit, it's marked as top secret and for Canadian eyes only. That's correct? And even then, on this page specifically, it says that the following details some of the irregularities and possible PRC-linked FI activity. And for the purposes of the commission here today, PRC would be People's Republic of China.
Yes.
And FI would be foreign interference.
Yes.
You have 1 minute left.
Thank you, Madam Commissioner. And very briefly, although it isn't disclosed, Mr. Vigneault, you've talked about how you've spoken extensively about foreign interference in the public sphere since then. Or sorry, since 2018.
Yeah, yeah.
And this report is dated November 29th, 2019.
That's correct.
And it's possible due to either the temporal effect or the leaks that there is some information in this report that may have been reported on publicly since then.
Yes, but just to be clear, being reported on publicly doesn't mean that it's been declassified.
Understood, but there is certain information in this report where if somebody else were to look at it on an unredacted form, they could recognize that it had been released to the public and was in the public domain.
It's possible. I don't know, I don't remember the specific details underneath this report. But again, as was mentioned by your colleague, previous counsel, it's not because information, classified information has been made in the public domain that is something that is not injurious anymore and therefore can be talked about publicly.
And Madam Commissioner, I just have one final question.
Yeah, that is the last one.
Yes. And for the commission to confirm that that's the case, they would need to be able to see the unredacted version of the document and test those claims themselves.
The commission has not only the full explanation of each of the reasons why this specific document, the specific portions of these documents has been redacted, but they have all of the information from all agencies of the government relevant to the terms of reference, unredacted, to be with clear counsel to be able to read everything.
Those are my questions.
Thank you.
Madam Commissioner. Thank you.
Thank you.
Maître Leblanc? Je comprends que c'est vous exclusivement.
I think that you're the only one asking questions.
My name is Christian Leblanc from FASCN. I represent the Media Coalition that is comprised of La Société Radio-Canada, CBC, le Journal de la Presse, CTV, Global, Torstar, Média QMI, and Groupe TVA. Sorry to say that, but most of my questions will also be aimed at yourself, Mr. Vigneault, but I will have other questions to you, Mr. Rogers. We're here this week to make sure to try to find solutions, which is the challenge of this commission that you yourself, Mr. Vigneault, alluded to, but that everybody here knows, which is inform Canadian on what happened here while maintaining, and we have to recognize that, certain documents and information that have to remain secret. But practically and concretely, we saw documents that have been redacted by your service and other services, some of which are giving us a lot of information and others not a lot. But still, would you agree that this is an exercise that is important and is conducive to inform the Canadian public and the Commission as to what happened here?
Sorry, when you say this exercise, you mean what?
The redaction exercise, the exercise that's been done with the 13 documents that is now filed with this commission. And so just to be clear, there's also a letter from the government that is accompanying these documents. I'm sure you saw it before.
Yes.
Do you agree with that letter?
Yes, I do.
Part of that letter says that that exercise is very time-consuming. We saw 200 hours. Also, part of that letter says that it would not be sustainable. To be clear, and practically speaking for the Commission and the Canadian public, can you reassure us that if your organization is asked by the Commission to do that type of exercise, it will do it?
I can reassure the commission, the commissioner, that we will abide by the terms of reference, and we will. You have my personal commitment that we'll do everything we can to support the commission. It is important for Canadians. It's important for the commission, and if we need to build resilience in Canadian society, that's what we need to be able to do.
I appreciate the answer, and thank you for that. But my question was because once this is over, the commission will need to proceed. What will happen concretely if you're being asked to redact documents or to look at documents and ask if any of those documents can be publicly released? Will your department do the job?
The commission has my commitment that CSIS will respect the terms of reference and the engagement with the Commission.
Are, in your mind, the term of reference including any request by the Commission to look at documents and see if part of classified documents could be released publicly?
Absolutely.
Thank you. We saw that there was other ways that could help the Commission and the public to understand, amongst other summaries. Mr. Court Reporter, could you put on the screen document CFE2? It's the RR report, and more specifically, the report with respect to the analysis and recommendations. So I'm sure you're familiar with this. You've been 20 years in the, but so this is the commission on Mr. Harar by Justice O'Connor. I just want to read a few extracts to you from that report, and it's page 295. It's under title CSIS Summary. And in that part of the RR report, Justice O'Connor explains what happened with summaries. And so I don't want to read everything because time is of the essence, but at the middle of the page, he says the government took a more restrictive view, and this is about the summaries, of what could be disclosed than did Commission counsel. Mr. Atke was involved in this process in the role of amicus curiae and agreed with the Commission's counsel's position. This is on the context is on the summaries that could be published. Jump to 3.12, revised process. The government's challenged my ruling on the summary because they could never, this is me talking, because they could never agree, of in-camera evidence from CSIS caused me to rethink parts of the process I had established for the factual inquiry. The nature of the disagreements over what could be disclosed was such that I believe that trying to resolve them, most likely through litigation, would result in considerable delay and might seriously impair the inquiry work. In effect, I don't know if it's to your knowledge, but I can tell you that the summary process was abandoned. Is that to your knowledge?
I'm not familiar with.
Concluding observation by Justice O'Connor. Here's what he says. As I look back at the inquiry process, I am satisfied that it worked as well as it could be expected given the extent and nature of the NSC claims asserted by the government. For everybody here, NSC is national security claims, correct?
Confidence, yeah.
I'm not sure. In the context of this document, that sounds plausible.
However, the public hearing part of the inquiry could have been more comprehensive than it turned out to be if the government had not, for over a year, asserted NSC claims over a good deal of information that eventually was made public, either as a result of the government's decision to redact certain documents beginning in June 2005 or through this report. Were you aware of, I want to take the most neutral word, those complications that arise in the RR inquiry over summaries?
Broadly speaking, I'm aware of the context, not the specifics.
And how can you reassure the Canadian public and the Commission that anything will be different this time around?
What I can say is that I would hesitate to draw any conclusions between this particular process and the one that we're undergoing right now. As we've heard this morning and what my colleagues have reiterated, the government has steadily increased in its desire and an application of transparency principles. My colleagues have been saying much more publicly than ever before. We've seen the government commit to terms of reference, which does not just include summaries, but includes the option of summaries. I think what we speak to is a proportionate number of redacted documents, in-camera hearings, and a commitment from us and the government to undergo some combination of those processes to help ensure that the commitment's mandate can be fulfilled and transparency can be achieved for Canadians. So what I can say is that, we on the public service side are bound by those terms, and we will diligently apply them. And I can't speak to what happened 20 years ago, but I am optimistic that we can find a path this time.
Did you have any discussions within government as to how these summaries could be achieved?
The process of taking classified information and writing documents for public release is something that happens within the government context. So the notion of summarizing documents is not necessarily new and is one that, as was mentioned previously by Mr. Vigneault, we undertook in the for the independent special rapporteur. We can, continue to build on that process in ways that are necessary as the Commission decides.
Did you have any specific discussions with respect to this commission about summaries with anybody in government?
Within government, certainly in the deliberations into leading how we could facilitate the Commission the fulfillment of its mandate, as represented in the letter, we agreed that summaries would be one tool that we could use.
Did you have any discussions about summaries with Mr. Vigneault?
I don't recall a specific time that we had that discussion, but I'm sure we have.
Madame la Commissaire, si je peux me permettre, yes.
If you'll allow me.
Those discussions, and I have said on the record, I'm perfectly comfortable with the way the December 15th letter from the government has been written. And so I can reassure the Commission and Canadians that, we are absolutely driven to fulfill the terms of reference, including to the summaries.
So, Mr. Vigneault, now that you're bringing it up, and I share the same concern than my friend in interrupting the CSIS director, but anyway, did you get specific instruction from government or anybody else that you should and your department should make sure that summaries and the most public summaries could be achieved? Is that a discussion you had?
There's been numerous discussions in the government leading up to the terms of reference, the issuance of terms of reference, and the letter, the December 15 letter, that there was a need to be able to support the Commission and a need to inform Canadians about foreign interference in order to build their resilience and reassure Canadians, especially about the electoral processes, that there will be a need to have more information in the public domain. And that is exactly the commitment that we have provided today to the Commission.
Good. And as we explored before, you know that time is of the essence, and I'm guessing that this undertaking is also, you also take into account that this can be achievable in this time frame, this being the Commission's time frame. Correct, Mr. Vigneault?
I'm sure that it's going to be complicated, and I'm sure that everybody will be absolutely driven towards meeting the terms of reference of this Commission.
And that would be the same answer for you, Mr. Rogers?
Yes, I agree.
Thank you. At the same page, just a bit down the page, middle of the page, Justice O'Connor says, however, in time, the implications of that overclaiming, because he also did conclude, as we heard yesterday, that there's overclaiming for classification. So, however, in time, the implications of that overclaiming for inquiry became clear. I raised this issue to highlight the fact that overclaiming exacerbates the transparency and procedural fairness problems that inevitably accompany any proceedings that cannot be fully open because of NSC concerns. It also promotes public suspicion and cynicism about legitimate claims by government of national security confidentiality. It is very important that at the outset of proceedings of this kind, every possible effort be made to avoid overclaiming. Do you agree with that, Mr. Vigneault?
It's first in a very long time that I'm seeing this statement. So I agree with the principle that, la teneur du propos, but I think it's, Madame la Commissaire.
Or the basic idea behind this.
20 years have elapsed since then. The Federal Court of Canada, the National Security and Intelligence Review Agency, the National Security Intelligence Committee of Parliamentarians, all have access to very highly classified information, unredacted, to do their work, and they're able to produce documents, public decisions, public reports derived from very highly classified information, and it's happening, every month, every week sometimes, and so the process is working. It is challenging, but this is why national security is so important. The notion of transparency, which is very critical, and the notions of being able to protect our ability to do our work, which is also very critical for Canadians.
Let me be more precise. The last sentence of Justice O'Connor. It is very important that at the outset of proceedings of this kind, every possible effort be made to avoid overclaiming. Do you agree with that sentence? That every possible efforts at the outset should be made to avoid overclaiming?
I agree with the sentence, but what I understand, I'm not sure how it applies in the proceeding here, the sense that the Commission has received all the documentations with zero redactions.
Do you understand that at some point the Commission may decide that as part of its mandate, they would want to share as much as possible public information, and that it would be useful if the Commission know from the outset so that it can divulge as soon as it can public information to the public?
The Commission has the same terms of reference that we all have here, and I think we have a commitment from all of us that we will be supporting those terms of reference, and so from that point of view, absolutely.
Thank you. I would now like to refer the panel to a document that was Mr. Court Reporter filed under MDC 2.
Countering an update on recommendations to prevent foreign interference in Canadian democratic institutions is the name of the document. We have the English version up. Are you familiar with this report?
I wouldn't know, but
okay.
If there's a LeBlanc involved, there's no
yes,
link with
Minister Dominic LeBlanc and the former clerk of the Privy Council, Janice Charette.
And I have no family relations with Mr. LeBlanc, who will hear tomorrow, just for the record. If we take page 4 of that report, le rapport est assez catégorique.
The report is quite clear that the best defense to avoid interference is to equip Canadians with better knowledge. I'll read it in French. 4 reports put forward that the fact of providing citizens with knowledge constitutes the best defense against those who are trying to interfere in our democratic processes. Are you in agreement with that? Answer, yes, I am in agreement, but I have said so publicly several times. It is absolutely essential that we have effective organization like CSC and the RCMP and CSIS to protect Canadians, do the necessary work, but that is not sufficient to block the threat of foreign interference. Canadians themselves have to be educated. They have to understand, have the information needed, and that is what we have now been doing for some years now, make more information available in the public domain. So fully in agreement with the statement. Question, thank you. And what you're now saying, are you in agreement with the present Commission is an excellent forum to pursue the awareness of Canadians. So what you're saying is make the most information available in the public, and the Commission is in a good position to do so. Are you in agreement? Answer yes. Yes, they are so placed, while yet respecting the mandate, of course, Mr. Rogers. I fully agree as well. So, a question, so for the two of you, or for the government, you do agree that the Commission is an excellent forum to pursue this best defense of providing information, the most information possible? Answer, yes. As you are consulting your notes, sir, Madam Commissioner, allow me to say this. One of the important things, well, the procedures are such that but there's some adversarial coming and going in procedures such as this, but it's very important for you and the Commission and Canadians know that it's not only because we have a mandate to do so, because fundamentally we, the professionals of intelligence who do so day by day in Canada, are in full agreement that the Canadians need to be better informed, better to protect themselves. So I understand that there's some coming and going here, but I want all Canadians to understand that we need more dialogue, more commitment, while yet respecting and protecting information as covered by the law. I'm very happy to hear you say that, Mr. Vigneault, and that everybody also hear you say so. But just to explain, there is no adversarial process here. But let me say this. When this week is over, we all agree that the right to the public to information is important, and it's even more important when we're talking about foreign interference in our elections. Okay, we're agreed on that. We're also very aware of the fact that an agency such as yours must sometimes act in secret. My colleagues of the Commission and Madam Commissioner next week will have to have a very concrete meeting, and they'll be stuck, so to speak, with things that they have to do and things that might be secret, might not be secret, etc. And it's in this idea of trying to inform the public. And what I'm trying to do here, and I'm not criticizing here, but over and above these general sentences that are these general wording, we're trying to find a concrete way of going forward. So I'm trying to avail myself of your presence and your great opportunity to learn more. Everybody's on the same page here, no infighting. So if we look at what happened in the past, I'm trying to see what, according to you, we can avoid the same problems, and that's for the benefit of all. I think and I'm happy you raised that. If we look at what has been done concretely these last some years, public speeches, publications, the working group on the security of elections, which published each general election based on very highly classified documents, an unclassified report on the election, the panel created by the government to be able to have senior public servants supervise elections during the writ period. Documents written for Canadians, how to protect yourself from foreign interference, published in several different languages. I think it's important to have a look at that. These very concrete things that were done to go along the lines that you're suggesting, and therefore we have to see that in the context of what's being said today, the commitment of the government and of we personally, the intelligence agency, to support the Commission. I am in full agreement, therefore, with what you've just said. Thank you. Question. Let's look at NDC 1, court reporter, document, please.
6. So this is an extract of the National Security Transparency document. I don't know if you're familiar with that, Mr. Vigneault.
I'm familiar with the group. I've not had a chance to review the document before, but I'm familiar with the exercise.
And Mr. Roger, I saw you nodding. You're familiar with that document?
Familiar. It has been some time since I've read this, but
okay.
Yes.
So I'll read you an extract of principle number 2. that says information is not to be protected to prevent embarrassment or to conceal inefficiency, errors, or problems. Do you agree with that principle, Mr. Vigneault?
Absolument.
Absolutely.
Agree with that principle?
Yes.
And we agree, I can tell you, but we can take, I don't think it would be worthwhile to take the time, but we agree that in these principles, and certainly under principle 2, time, effort, the fact that it may be complicated does not come into play. Do we agree with that, Mr. Rogers?
I agree that that's not represented here, yes.
Mr. Vigneault?
Same answer, yes. Just to be clear, I think I agree with this statement. I'm not sure exactly your question, where your question was going.
I just wanted to make sure that your organization, under your leadership and your testimony today, would not redact information because it would protect embarrassment, conceal inefficiency, errors, or problems. And I think you answered that.
I answered, and I can tell you that, again, we have, through the federal court, the National Security Committee of Intelligence of Parliamentarians and National Security Intelligence Review Agency, they have access to everything, and part of their work is if there were to be something that is embarrassing, they would be revealing it. So I can tell you that not only do I agree with it, but this is how the system works.
And do you agree that it would be the same answer if it would be to protect the reputation of somebody? That you would not redact something simply to protect the reputation of somebody?
Just to be clear, we would not the reputation of an individual like myself, but we would be not releasing public information in order to protect the reputation potentially of an individual that is in the public or that has other privacy consideration. So I think it's a very important nuance here that, we have privacy rules that we have to respect if we're to be intelligence about an individual in the public domain, versus here, which is, to not use classification to essentially protect someone like myself, from embarrassment. So,
or a politician, an elected official.
Yes.
Mr. Rogers, do you agree with that answer?
I agree with Mr. Vigneault.
On that, Madam Commissioner, it will be my last question. Merci beaucoup. Thank you very much for your time and appearing here today.
Merci.
Thank you.
Merci.
So the next one is Human Rights Coalition. Mrs. Taylor.
Good afternoon, Commissioner Hogue and members of the panel. My name is Hannah Taylor, Counsel for the Human Rights Coalition. And the coalition is comprised of community groups engaged in work for the rights of diaspora communities, particularly vulnerable to transnational oppression or the effects of foreign interference. My questions will be for Ms. Tayeb and Mr. Vigneault. Thank you also, Mr. Rogers, for your time today. Turning to you first, Ms. Tayeb. We heard this morning that there are specific teams at CSE and CSIS that handle these classification issues and specialize in ensuring that the agency adheres to its legal obligations when it comes to disclosure. But to confirm, have you been involved in decisions relating to disclosure of information gathered by CSE or agencies you've worked with in the past?
Yes, absolutely. In various positions, including this one, where on occasion I'm asked to review at my level certain disclosures of information.
Okay, thank you. And in the decisions that you have experience with, has the risk of serious bodily harm or death ever been a factor weighing in favor of disclosure of information gathered by the agencies that you've worked with?
I think the way of answering that is absolutely in the context of when we receive or when we gather information where there's a threat of serious harm. And for us, it could be a wide variety of public safety issues to include a threat of death or bodily harm. The disclosure for us, though, in the manner in which we would do that is often through, as I described earlier, would be another government department that would be responsible for then handling that information. So absolutely, we would work in these circumstances, and we do it regularly, where we will work quickly to either sanitize or declassify the information, so it could be used by the responsible agency. I just specify that because it's to mean that it's not necessarily CSE that would be responsible for taking that action, but we would make it available to the agency who would be responsible for taking that action.
Okay, thank you. And when it comes to decisions like that, has information been disclosed in some capacity in every case where serious bodily harm or the threat of death is involved, or only some of the time?
That's a difficult question for me. In my experience, I can't imagine where we wouldn't act to do that, but I couldn't answer that question conclusively. There might be other circumstances that I'm unaware of, but generally speaking, that would be the case.
In your experience, has the risk of death or serious bodily harm been taken into consideration with regard to a disclosure decision only when it applied to a Canadian or a person in Canada? Or maybe another way of phrasing the question, has it also been taken into consideration when the person at risk is someone associated with a person in Canada, even though they may be located outside of the country?
Yes, absolutely. And I can offer that beyond that, we have relationships with other foreign agencies for whom we would offer the same consideration.
And my last question for you, Ms. Tayeb, to your knowledge, when the issue of personal security has been taken into account in disclosure decisions, has serious bodily harm been understood to include serious mental harm for the purposes of decision-making regarding disclosure?
I can't think of anything that would fall into that category, though I can say it would certainly come into consideration.
Okay, thank you. Now turning to you, Mr. Vigneault, thank you also for speaking with us today. To get started, in the past, have you been involved in decisions to disclose information for the purpose of taking measures to reduce a threat to the security to security involving foreign influence activities? So you make a decision to disclose that information in order to respond to a threat?
Yes, I have.
Okay. And have you been involved in decisions to disclose information when the foreign influence activity at issue includes acts of transnational repression against a targeted diaspora community?
Yes, I have.
Okay. And when this has been the threat at issue, has the information been disclosed every time, just some of the time?
So every time there is a risk of bodily harm, our practice is to engage with the police of local jurisdiction or often the RCMP. So we would be, we are not a law enforcement agency. So if we have information, we do not have the means to be able to act on it ourselves. So we would be, working, if there is that risk of bodily harm, we would be sharing this with the police.
Okay. And would information be disclosed when acts of transnational repression take forms other than bodily harm or actions that result in bodily harm? Or is that really the focus?
There's
And you mentioned Section 19 of the CSIS Act this morning, Mr. Vigneault. I don't think I have to put it to you, as I expect you're likely very familiar. If it's helpful, I can ask the court operator to do so, but maybe before I do, I'll ask the question. My understanding is that the service may disclose information obtained in the course of its work where the information relates to the conduct of the international affairs of Canada, to the Minister of Foreign Affairs or a person designated by the Minister of Foreign Affairs.
I think in the context of Minister of Foreign Affairs, I think you referred to Section 16 of the CSIS Act, where when we conduct foreign intelligence collection.
I'm referring to Section 19(2)(b). Commissioner, would it be helpful?
So
if I
maybe,
brought it up,
yeah, might be more useful.
Okay. So if I could ask the court operator to pull up the document submitted by Human Rights Coalition with the document number HRC2, and then just at page 1. And we can just scroll down to Section 19(2). There we go. Yeah, that's great. Thank you so much. So looking at this section, It states, I can begin at 19.1, information obtained in the performance of the duties and functions of the service under this act shall not be disclosed except in accordance with this section. And then 19.2b states, service may disclose information referred to in subsection 1 for the purpose of the performance of its duties and functions under this act or the administration or enforcement of this act or is required by any other law, and may also disclose this information under subsection B where the information relates to the conduct of the international affairs of Canada to the Minister of Foreign Affairs or person designated by them. That's correct? Or you're
Yes. It probably would be easier if the entire section of the act were there as opposed to portions of it, but I trust that, you copied that. So
Okay.
not sure what the question is, however, sorry.
No, that's okay. Really, I was asking if this was the case, just confirming you're familiar with this. The question is, to clarify, you would not get involved in a decision involving a section, right? Since it's the minister's decision to make when it comes to designation of a person.
No, this is the minister, it is the information that CSIS has in its possession, is responsibility of CSIS to manage. Some information, that's why I thought you were referring to section 16 of the act, because we are conducting some collection operations on behalf of the Minister of Foreign Affairs. So there is a responsibility then from the Minister of Foreign Affairs under section 16 to determine the distribution of this information. But that's why I was a little bit confused by the question. I'm
No,
sorry.
that's fair, and I could have likely been more clear. But I guess just to confirm, who the person is designated, the person that the information is disclosed to under this section would be designated by the minister, as opposed to you would not be involved in that decision.
Just give me 1 second, please.
Do you need to read the entire section?
I think honestly, and I'm not sure that, I would probably need to read the entire section. I'm
Okay,
sorry.
we can also, that's okay.
But I also know you were on their timeline, so.
Yeah, let's move on, maybe.
Okay.
So I guess perhaps one more question about this section, maybe it will answer. Do you know, and if you don't, that's also okay, but when it comes to, I guess the question would be, who decides whether a piece of information is related to international affairs? Would that be CSIS or would that be Foreign Affairs?
This is not the way this is operated, CSIS determines we work with the Department of Global Affairs on these issues.
Okay.
But it's also, this is one of the area where there's also the fact that the act is showing its age. This is one of the section of the act that is currently being in consultations with Canadians to determine, how to modernize it.
Okay.
So I think this might be one of these the areas that are a bit unclear in the context of 2024.
You have 1 minute left.
Oh, thank you, Commissioner. Actually, I have one more question. You would agree that transnational repression relates to international affairs, correct?
Absolutely. It relates to international affairs, but not exclusively, but yes.
Okay. Thank you very much, Mr. Vigneault, and thank you, Commissioner. We have no further questions.
Thank you.
Thank you.
So the next one will be Mr. Doody. I think you're in the room. Okay.
Good afternoon, Commissioner Hogue and the panel.
Good afternoon.
I'm John Duty. I represent the Ukrainian-Canadian Congress. Got a few questions, just mainly to follow up on things that were said this morning. There was discussion that CSE and CSIS, among other agencies, received directions from Cabinet with priorities for national security. Is that correct?
Yes.
Okay. And is this like a memo of Cabinet?
I think what you're referring to is the intelligence priorities that Mr. Vigneault referred to this morning, and this is a cabinet decision, yes.
Okay, so that would not be disclosed. That would be covered by cabinet privilege?
The advice that leads to a cabinet discussion may be cabinet confidence. The intelligence priorities themselves, while classified, would be available to the commission.
But not to the public?
Not to the public.
Okay. And if cabinet privilege is claimed, there's no equivalent 38 routine that you can apply for. 39 claimed there's no exemptions.
I would like to clarify, once established, the intelligence priorities themselves are not, are things that are disclosed and that the Commission has. Or could have. I would have to confirm, but available.
Do you know if the Commission's been provided with those intelligence priorities?
I'm not sure specifically right now.
Following up on a question asked by the Media Coalition in relation to the December 15th letter from the government, you know what letter I'm referring to? So in there, on page 6, the government wrote, quote, the letter notes, that this level of NSC review is not sustainable if replicated over a longer term. It is clear that redactions of documents on a large scale will not be a productive way forward within the timeframe allotted. So do you agree with the government's opinion on that it would not be possible within the timeframe allotted?
I think that depends on the volume of documents selected for release and a number of other factors, but I could imagine such a possibility, which is why we are, on the government side, also mentioning in that letter the ability to use other processes to achieve the same ends.
Right, but if the Commission insisted on that level of review, would the government comply?
I think I would have to refer back to the same answer Mr. Vigneault gave earlier, that we are absolutely bound to support the Commission.
And is that one of the rationales for the tailored process that you said has been created for the Commission?
I think that we've touched on this a bit earlier today, and please jump in, colleagues, if you like, but intelligence documents which were written for a specific set of readers who have an intelligence, who have a security classification in a certain context, redacting those documents does not provide the complete picture and is a very challenging thing to do while also not necessarily achieving the optimal result. So I wouldn't want to say that it is solely a question of effort as to why we suggest doing other things. Producing summaries and right to release documents may be the more effective tool for transparency, and likely are.
And can you explain what about this process is tailored that separates it from the traditional process?
Well, when we say tailored, I think we're speaking about the fact that we are, there's a very specific process in the letter that Alia and David spoke about earlier around the challenge function, where if the Commission were to challenge a redaction, there is a process within the public service that would respond to that. That is bespoke to the Commission. As David said earlier, Mr. Vigneault said earlier, we're also not operating business as usual because business as usual might be receiving a request and redacting documents. We are hoping for a more engaged process where we seek to prioritize and maximize the use of the time that the Commission has.
If that's useful, I can give you an example.
Sure.
So if the Commission in its work, there's a specific issue, there's a body of intelligence that speaks to an issue, and they say, the commissioner was to say, I want to be able to say something publicly about that. I need to be able to say something publicly about this issue. There's two approaches. One is, can ask the government, can you write summaries of these different reports? Or alternatively, what we call write for release. So the Commission can write a summary itself and work with the government to be able to say, what are the portion here that if they were to be released would be injurious to national security and therefore contrary to the terms of reference. And so that way, that's the kind of, if you want a back and forth, so that the Commissioner's intent can be achieved, and the specific words can be adjusted to obfuscate the specific human source or technical source or third-party information.
But providing summaries for redacted information is not new or novel. That's a traditional response to 38 claims.
Yes, but what is happening, as I mentioned, with the federal court, with the two review bodies, NCIRA and NSICOP. So NCIRA is the National Security and Intelligence Review Agency, NSICOP, the National Security and Intelligence Committee of Parliamentarians. They write understanding that they want the report to be released. And then so they provide the government with that report, and then there is an exchange to say, no, that specific information, if they were to be released this specific way, would be injurious. If you were to be, phrased this way, would be releasable. And so it is. That's why I say there is this is not the normal practice to be able to do summaries on an ongoing basis. Same thing with ATIP, for example. ATIP, the document will be taken and all of the information that, meets one of the legislated category would be removed. So that's when you get those documents with lots of black information.
If I can add just one thing to that, because your question was what's novel about this. I think the aspect that is different is some of what we put as the amended process for this, which is that as soon as something is detected to be problematic, it will immediately be raised up to a certain level within the organization to seek the correct solution to remedy the issue. So correct, the writing of summaries is not never been used before, but the process that's been outlined in being more proactive is what is new here.
So it's essentially the expediency at which the government will process the request that's novel.
And the proactive nature of seeking the solution ahead of time.
And it's been mentioned a number of times today that despite any redactions claimed, the commissioner and commission counsel have access to the unredacted documents. Does that factor into the decision on redactions, knowing that the commission has everything? Does that impact how much you believe should be released to the public?
Not from a CSE perspective, no.
I would say writ large, as was outlined earlier, the government has to go through line by line with subject matter experts and understand the specific reasons that information has to be redacted. It doesn't change anything, but it does exemplify that we have to go through that process in good faith, because there are others who will see the unredacted documents, including the commission, potentially the federal court and others. So we know that we have to operate in good faith, which of course we would do.
If I can also add just one point. In terms of reference, also provide the opportunity for the commissioner to hold some of the hearings ex parte, which provides the commissioner and council the opportunity to ask very specific questions about very highly classified information and really dig into the issue, with all of the information available. And so that is an opportunity that the commissioner and commission council will have to determine how they want to use that to be able to press on an issue and then determine what and how.
For all three of you, if those in-camera sessions occur, parties and participants will not have standing to make submissions there. Do you have any amicus or other things? Do you have any recommendations on how the public
on how to achieve that?
Yeah, as would I.
So no suggestions, no assistance, just whatever the commission comes up with?
Well, I can imagine a variety of things the commission. That would be up to the commission, but all of those are opportunities we'd be willing to explore with the commission.
Thank you. Those are my questions.
Thank you.
Madam Commissioner, Natalia Rodriguez, Commission Counsel. This might be an opportune time for the afternoon break.
Yes, it is.
Thank you.
Order, please. Alors, s'il vous plaît. This hearing is now in recess for 20 minutes. La séance est en pause pour 20 minutes.
3:30, I guess. Yeah.
The commission will be commencing shortly. La commission va débuter sous peu. Order, please. À l'ordre, s'il vous plaît. This sitting of the Foreign Interference Commission is back in session. Cette séance de la Commission sur l'ingérence étrangère a repris.
Alors maintenant, c'est
It's now time for Councillor Sirois pour the Russian-Canadian Democratic Alliance. Maître Sirois.
Merci, Madame la Commissaire.
Thank you, Madam Commissioner. Thank you, panelists, for being here today for these important issues.
Power Law, Jurist Power, and I represent the Russian-Canadian Democratic Alliance. The RCDA is a national nonprofit organization supporting the development of the Russian-Canadian community around the ideals of democracy, human rights, civil liberties, and the rule of law. I will be asking some questions concerning foreign interference by Russia and the disproportionate impact of this interference on members of the Russian Canadian community. Premièrement, Directeur Vigneault.
So first of all, Director Vigneault, I'd like to come back to an answer you provided earlier to my colleague John Mather earlier this afternoon. You said, and this is from my notes,
information to protect themselves, but they also rely on the security agencies to work effectively to be protected. Vous êtes toujours d'accord avec cette affirmation?
Are we in agreement with that statement? Yes, answer yes, of course I am. Do you also agree that for a government agency like CSIS to function effectively, they have to be accountable to the public? Answer, absolutely. It's the difference between a security agency in a democratic country like Canada and in other countries. Yes, indeed. And we're very aware of that situation, particularly us. And this would start by the disclosure of accountability, which is important for the proper working of CSIS, goes through the disclosure of the documents to the public and to inquiries such as this in part, yes. Thank you. That's my questions of follow-up from this morning. Now, I'd like now to put up the document CAN 528. Thank you. And while that is being put up, they're fine. We go.
Intelligence threats to election task force update on foreign interference. Threats to Canadian democratic institutions. It's dated September 13, 2021. J'imagine que vous connaissez tous.
Of course, I guess you're all familiar with this document. Yes, indeed. Do you know who this report was made for? The task force had been implemented to pull together the security agencies and the law enforcement agencies like the RCMP and also with World Affairs in order to pull together all of the information or intelligence in real time that could affect or result in foreign interference during an election. And the document was pulled together by this working group and handed over to several and different bodies within the Canadian government. So we don't know specifically what persons received it. Several persons or bodies received it. I received a copy. I imagine both my colleagues here with me also and others in the various departments. So it was an information document on what was going on during the election period.
Document, please. From page 4, we see information, very limited information about Russian interference. Can you scroll down, please, a little bit? When we arrive at the, yes, exactly. Can you scroll down again? We'll go all the way to page 6. See that most of the information is redacted from the Russian interference section. And the information that's there is, like, I've read it and it's very general in nature. Would you agree with that?
I have not reread the unredacted version, but by experience, yeah, that would be the case. Yes, and that explains the information that is, protected is classified information, and the information that has been released here specifically is information that was not injurious. So sometimes it does create that perception. Absolutely.
Donc, on ne va pas trouver d'informations spécifiques sur.
So we don't get any specific information on what the specific threats there might have been for any specific groups like the Russian diaspora, for example. The purpose, once again, well, today I'm talking about the process, Part D of the Commission's mandate. So a document like this is once again wasn't actually written to be made public, but to inform certain people with high security clearance who had a need to have that information, and it was written to be useful and precise. So when we remove the classified information from it, it gives the impression that there's nothing much left. Now, obviously, I can't talk specifically about the specific information that has been redacted. Can we now go to RCD7 document, please? RCD7. And as it comes up, it's called sur l'ingérence étrangère. That is there to explain to communities like the Russian diaspora and other diaspora and members of the public, and to make them aware about foreign interference and the measures they could take in response to threats arising from foreign interference. We await the document. I assume you're familiar with the document. Answer yes.
We see a quote that says, the last paragraph says, hostile foreign actors also target the fabric of Canada's multicultural society, seeking to influence Canadian communities, including through threats, manipulation, and coercion. Some of these communities are vulnerable targets of foreign interference from states seeking to exploit them in various ways to advance the foreign state's interest, sometimes to the detriment of Canadian values and freedom. Vous savez, j'imagine que la diaspora, les membres de leur famille.
I guess you know the members of the diaspora and members of their family that are in the country of origin are particularly targeted by this foreign interference. Yes, they are often collateral victims of foreign interference because the foreign interference is exercised here in Canada, and the families of the victims in the country of origin are sometimes victims of coercion and such not, and that's the local government that does that, of course, acting against the family, and this coercion could be related to members of the diaspora in Canada. Yes, indeed. Yes, it's one of the perverse effects of foreign interference, and one of the reasons, or the important reasons for which we want to talk about it, and then we actually publish this document here. This brings us to say that the diaspora of Canadian in Canada are particularly affected by foreign interference compared to the general population. Indeed. Absolutely. One of the things that is important to note, Madam Commissioner, is that the public debate or public discussion on foreign interference put a lot of accents on what happened around the elections. And, of course, justifiably so. It's a fundamental issue in a democracy. But when we talk about foreign interference, and this document is a good example of it, it details how the communities are also targeted. They're being made victims by foreign interference actors. And that's what we call, the previous lawyer talked about transnational repression. Well, that's exactly what's happening here. These are people that are victims of coercion and retribution on their here in Canada, and as you said, about their families in the country of origin. And considering that they're more affected than the general population, we heard a lot about the interests of the general population about having access to information on foreign. But since the diaspora itself is more affected than the general population by foreign interference, can we say that the diaspora has a even greater interest in having access to the information than the general population? Well, I would agree with the statement that the diaspora groups here in Canada, though Canadians of foreign origin, are more often victims, and we need to find a way of giving them the information they need to protect them. So 2 specific points here. We translate this document to several languages, including in Russian, to ensure that the communities who have not yet learned French or English can have access to the information. And also in the case of CSIS, we implement in 2019 internal resources for consultation with the Canadian communities. And these people engage the communities directly in order to create links or bridges with CSIS and other organizations. So I think we'll be asking some questions of Minister LeBlanc tomorrow on that. Yeah, 1 minute, sir. And I only have one question, so that's great. Thank you, Madam Commissioner. So if we understand that the diaspora has a particular interest in having access to this information on foreign interference, can we say that the diaspora needs the information on foreign interference, including information that might not be, but is related to the work of the Commission in order better to protect themselves against foreign interference on important issues like security, freedom, and their other fundamental rights? Answer, absolutely. And I think that's exactly the heart of the issue here. How, with the information and the knowledge that the government has, can we help these population groups? There's not only the government, but there are other entities that can do so. And if we want to continue to do this and be able to intervene specifically, including when there's threats to the physical integrity or the life of a person, we can also be able to protect them. So these two elements might come into contradiction. We have to have transparency, but we also have to be able to conserve our ability of operating as we do, and so that requires some secrecy. Thank you very much.
Now the next one is...
Le prochain intervenant, c'est le Navaka Choudry au nom de Jenny Kwan.
Good afternoon. My name is Sujit Chaudhry. I'm counsel to Jenny Kwan, Member of Parliament for Vancouver East. The focus of my questions will be a bit narrower and a bit different than what some of my colleagues have put to you, and it actually arises from two sentences in the interview summary. So it might be helpful to give the document ID and perhaps put it up. It's WIT3, and it's page 19, the middle of the page, and this was actually, I think it was Mr. Rogers who was addressing this issue. So if we could go to page 19, please. Pardon me, page 18. If you could just scroll down a bit. Here, whoops, go back up. Super, great. So there's the paragraph that begins, if an individual. So let me just read this out. There's two sentences here that I want to drill down on. So the first sentence says, if an individual does not have the appropriate clearance and/or indoctrination, but PCO needs to communicate certain classified materials to them, PCO will sometimes initiate a process to get that individual the appropriate clearance or indoctrinations. And then the second sentence says, as an alternative, we can sanitize the information to reduce the level of classification. So I just want to drill down on that a little bit, if I might. And I think so the questions are to the whole panel, but I'm sorry, Ms. Tayeb, I think it's mostly Mr. Vigneault and Mr.
Chaudhry?
Yes.
Can you just speak a bit more slowly?
Of course. I'm sorry about that, Madam Commissioner. And so I think the questions will be directed mostly to Mr. Rogers and Mr. Vigneault. And what I'm trying to understand is how this works from a machinery of government perspective. And so I want to drill in first to a couple of examples regarding security clearances for parliamentarians. And so the first example arises from a recommendation made by the Special Rapporteur, Mr. David Johnston. And as you'll know, he recommended in his report that the government begin the process immediately of working with leaders of opposition parties to grant them the requisite clearances so that they could review the classified version of his report. And so I want to ask you a couple of questions, if I may. Where CSIS and the P in obtaining the requisite security clearances?
Or security clearances, which the Privy Council Office would administratively process. So, security clearances for all of us under involve a consistent process, which we all undergo, of interviews and information. That's something which we initiated on behalf of that direction, and for the leaders of the opposition who chose to avail themselves of that, we processed those clearances.
Sure, and it's a matter of public record that Mr. Singh, the leader of the NDP, did choose to avail himself of that option.
That's correct.
And it's my understanding that Mr. Singh requested as well that clearance be granted to a couple of aides or members of his party as well.
That's correct.
Right. And so how many aides did he ask clearances be granted to? Do you recall?
At least one, as I recall, I believe.
And it's my understanding that Mr. Singh was granted a security clearance?
Yes, that's correct.
Yes, and were his aides granted a security clearance as well to assist him?
Yes.
And do you roughly know how long that process took?
I do not recall the specific time frame.
Okay. And so I'd like to ask the same sets of questions about NSICOP that we've heard about as well. And so as you know, under the NSICOP Act and under the regulations, it's required that members of NSICOP obtain a top secret security clearance, correct?
Can you just say what NCCOP stands for the
Of
public?
course. Yes, the National Security and Intelligence Committee of Parliamentarians. And Mr. Vigneault had referred to NSICOP previously in some of his testimony, but thank you, Madam Commissioner. And so the members of NSICOP are members of Parliament, and they're also senators, correct?
That's correct.
Right. And so it's required then for a member of NSICOP to go through some type of a security clearance process as well.
Yes, that's correct.
Right. And again, in your experience, how long a process is that? How long does it take?
Those processes range depending on the complexity of the cases involved. I can't tell you specifically how long any of those offhand would have taken. It can range from weeks to months.
Okay, great. All right. And so I'd like to pivot a bit to the second sentence here from page 18 of your interview. And I'd like to ask a couple of questions about the disclosure of classified information to parliamentarians, if I could. And so if I could, Mr. Registrar, if you could put up on the screen, please, the following document. It's JKW, many zeros, 21.
While that document is coming up, can I take the opportunity to just clarify my statement there, which is accurate?
Of course, sir.
Just to be clear, when I was referring to those couple of sentences that you quoted, my intention was more to convey that not everyone within the federal public service enjoys the same level of clearance. And so there may be an intelligence report which is necessary for a public servant or other member of the national community to see. And for instance, it may be top secret, while the individual needing to see it would have a secret clearance. And I understand your line of questioning is not about that, but that was the intention of my statement.
Thank you for the clarification, sir. Members of the panels, you'll see what we've put up on the screen here is a ministerial direction on threats to the security of Canada directed at Parliament and parliamentarians. You're all familiar with this document?
Yes.
And as you know, this was issued on May 16th, 2023, issued pursuant to Section 6 sub 2 of the CSIS Act by the Minister of Public Safety. Is that right?
Yes.
Yeah. Can we scroll down to Clause 3, please? So I'd like to read out Clause 3 for members of the public who might be watching. And it says, CSIS will seek wherever possible within the law and while protecting the security and integrity of national security and intelligence operations and investigations to ensure that parliamentarians are informed of threats to the security of Canada directed at them. This may involve direct disclosures or by working with other bodies such as the Government of Canada, departments, the RCMP, law enforcement, et cetera, as law permits. And so I have a question about how this clause would work in practice. Would this clause authorize CSIS to disclose classified information to a parliamentarian?
So this is not, this direction does not supersede the law. So the act is still applying. In order to accomplish this the intent of this clause. There's two different ways. One is that CSIS, if it were to be us, CSIS would be able to engage with the Member of Parliament and disclose information that is not classified, but is also provided by this information is provided by an expert intelligence professional who understand the classified information and provides the information to Member of Parliament in a non-classified way, but with the benefit of understanding what is classified. So there is one process. If for the purpose of achieving this classified information were to be necessary to be used, at that point, the CSIS will engage in, will use Section 12(1) of the CSIS Act and engage in a threat reduction measure, which then allows the disclosure of classified information with the specific intent of that action would be reducing the threat. So it's very clear that this is what the law stipulates.
And just to pick up on what you've just said, Mr. Vigneault, so when CSIS acts pursuant to Section 12 sub 1 of the CSIS Act, is it true then that the recipient of that classified information need not yet have or might never go through a security clearance process?
That is accurate. The person is informed of the nature of the information, informed of the injury that could happen if this information was to be released publicly, and counsel to not make that information public.
So then this leads to my last question, Madam Commissioner, which is about the May 2023 briefings that CSIS offered and provided to members of Parliament Kwan, Chong, and at that time, Member of Parliament O'Toole, to inform them that they were the targets of foreign interference. And so I know we can't ask you about the content of those briefings, but I want to understand the policy framework within which, and the legal framework within which those briefings take place. Were those briefings, did they take place pursuant to Section 12 sub 1 of the CSIS Act?
Madame la Commissaire, I think this is going into a territory that is not covered by Section D of this inquiry. I'd be happy to answer that question in due course during the work of the Commission.
Sorry, Commissioner. I was going to raise this, but the director beat me to it.
And I think it's right. You're going beyond what is contemplated by these hearings this week.
Okay, well, fair enough, Madam Commissioner. Thank you for your time, panel.
Thank you.
Thank you. Maid Vanert for Mr. Chong.
Madam Commissioner, Gib Van Aert for the Honourable Michael Chong, MP. Director, this morning you gave evidence about certain intelligence products that the service produces. You talked about raw intelligence and intelligence assessments and briefing notes. I want to ask a question about something that I think is covered under the category of briefing note, but you'll tell me, and that is the issues management note. Could you explain to the Commissioner what an issues management note is?
I'll give a general answer to this.
Sorry, having real trouble seeing where this is in term of reference D. It may be in A, maybe in B, certainly, but we're going to get there. Not today.
Well, this witness has given evidence about the sorts of intelligence products that the service prepares. I believe that an IMU is one of those products, and I wanted the Commission to understand what that product is.
For the time being, I'll permit the question, but I won't permit that you go very long with this line of questioning.
All right, well, I will.
To know what it's all about, it's something, but.
Absolutely. So an IMU note, an IM note is issues management product. So essentially it's when the service wants to convey information to different individuals, senior individuals in the government, to alert them of an issue that may, an operational issue, a media issue, an intelligence issue. It is one tool that we have to be able to inform specific individuals, provide some context and some information about what we will do about this information. So it is indeed a document that we use for to inform some specific individuals. But contrary to intelligence products, it would be always what we call a name distribution. So the specific individuals who should receive this information would be specified, in the process.
Thank you, Director. That's very helpful. And Commissioner, I want to follow up on that, but just to put everyone's minds at ease, I'm not going to be asking about any particular IMU. I'm not going to be asking about the contents of any IMUs. I want to understand the instrument. And so, Director, what you've just said, among other things, is that it is directed to specific senior officials. Do I understand that correctly to be, for instance, deputy ministers, ministers of the Crown, their chiefs of staff?
That would be accurate, yes.
Thank you. And you talked about specific issues that the service wants to bring to those people's attention. Is that right?
Yes, that's accurate.
Thank you. It's addressed to someone in particular. In contrast, tell me if I have this right, I think I understood from earlier today that some intelligence assessments, other products, are addressed to departments more generally and left to the departments to determine in their discretion whether they should be briefed up to more senior people or not. Is that right?
This is where I think, we're getting into more the specificity. It's hard for me to answer, to continue to answer this line of questions to be too generic, given the context.
Let me try again. I'm talking about intelligence assessments now, rather than IMUs.
Yeah.
Am I right in my understanding that an intelligence assessment prepared by the service will, at least sometimes, be directed not to anyone specifically, but to a department or maybe a unit within a department generally?
Yes, I think both are true. Like we can have, our assessments might be more going to a more general distribution. Sometimes if it's on a very sensitive topic, it might be more specifically issued to specific individuals. But I'm just adding this nuance, but I agree with the statement.
Thank you, Director. Turning back to IMUs, you mentioned that they're documents. They're, of course, sensitive documents. You're not sending them by email. Right.
Well, Commissioner, are we going to get to, I guess the question is whether you redact IMUs, because that I think would be the only thing that might fall into Part D.
Yes, I must say that I have difficulties understanding where you're going in terms of what we are doing this week in the context of.
So you're suggesting that I should leave these questions for March, Commissioner, is that?
Yes, it's a suggestion.
All right.
A very strong one.
All right, thank you. Well, very good. Well, in that case, à la prochaine, Monsieur le Directeur. J'espère de vous revoir dans...
I hope to see you again in a month. Thank you.
So, I think it's your turn, Matt Brooker.
And I have some welcome news. I think the government has no questions.
No question?
No re-examination, thank you.
No re-examination. So it means our day is over. So we'll reconvene tomorrow it's at 10 tomorrow morning? Yes. So tomorrow morning, 10 o'clock. Thank you.
Merci.
Thank you very much.
Merci beaucoup.
Order, please. Alors, s'il vous plaît. This sitting of the Foreign Interference Commission has adjourned until tomorrow at 10 a.m. Cette séance de la Commission d'interférence étrangère est levée jusqu'à demain à 10 heures.